Hi everyone, how's it going today? Happy Monday. Well, Monday for me. I don't know if it's Tuesday for some of the other guys. Maybe if you're in Australia. But we have a hearing today for Sarah Boone, and there's actually been some updates with Sarah Boone that I haven't covered yet because I wanted to wait for a major update. I guess I don't know. Is it better just to do small updates along the way and make videos on those, or just do a major update? I don't know. Let me know what you guys prefer. But with Sarah Boone, actually, you know what? Maybe it's better to do small updates along the way. That way, if I have something big to cover, it won't be like hours long. I don't know. We'll see. I'm going to edit this video, so hopefully it'll be structured a little bit better. But we have a hearing today with Sarah Boone, and Sarah Boone has filed 5 handwritten motions, and that was covered at the previous hearing. At that time, though, the judge had not received any of it yet. It was on its way over to his desk, and we have seen it already. It's already been uploaded onto the Orange County, close again. Orange County Court Records website. So it's already up there, already uploaded. I haven't covered it yet, but she put in 5 motions, and those 5 motions are, do I have it here? I think I could just pull it up really quick. Oh gosh, I did have it up. So they're about like 20 to 29 pages. Hi, American Dreamer. How are you doing today? Hi, Reese. Hello, hello. Well, good thing for the video, I could just cut this part out. Haha. Okay, so some of the motions that she requested. So one that really stood out to me, stood out to me, was the motion requesting immediate relief to the defendant by appointing effective standby counsel to aid and support in preparation of a criminal case for trial. So again, the judge had deemed that she forfeited her right to a public defender because of all the drama that went down. There were 3 attorneys in total that were public defenders that withdrew because of irreconcilable differences. There was 1 attorney that withdrew, the 4th one, but that was, I think his name was Padilla, and that was like her first attorney that she had for about 2 years. He also withdrew irreconcilable differences. So 4 attorneys total. Now she's requesting for someone to, come help her. And I'm like, oh, this doesn't sound unreasonable. Maybe the judge will grant this. We'll see. So she put in a motion for this, saying how she wants help, needs help, blah, blah, blah. She doesn't know what she's doing. And I was like, okay, it's good. It's good that she knows what her skills are at and, how they're not at. Because, there are some people out there who are going to, defend themselves. And they're like, oh, yeah, they're like overly confident. They're like, I can do what an attorney does. Yeah, no trading, no need to take the bar, LSATs, all that stuff. I got this. And I'm glad that she knows that it's going to be really tough for her. There's a lot of things that she would have to overcome. And, some of the stuff that she mentioned was her not really having, willy-nilly access to the internet, right? How she has limited access to like telephone calls. How is she going to be doing all the stuff when she can't print things, So it's a lot of stuff that it's going to be really hard for her. Oh, hi. Hello. Hi, guys. How are you doing today? How's it going? Hope you guys are doing well. So now we have some other motions that she filed, and I'm going to get to the video very shortly, was a temporary motion for a reservation of proposed costs to acquire investigator for defendant's defense in trial. That was the second motion. The other motion was temporary motion for reservation of proposed costs to acquire expert witnesses for defense. But a lot of these motions that she put in, it was like, I don't know who I'm going to depose. I don't know how long I'm going to be deposing them for. I don't know how much money I need. I don't know how much time I'm going to need because she, at this point, had not received her discovery. There are 2 boxes of discovery that she was supposed to get from Patricia Cashman. And we learned from the previous hearing that, well, it's not really easy to get stuff to someone who's, an inmate. There's a process to follow with the jail. And it seems like the judge was getting all of that in order. So now we have today's hearing, and supposedly by this point, all that should be in order. I think they were going to copy all the files on like a little USB thumb drive and somehow give that to Sarah Boone and then maybe get her set up with a laptop and all that stuff. All right, what's another motion that she wanted? Same thing, temporary motion for reservation proposed costs to acquire all witnesses for defendant's defense in trial. And again, she doesn't know how much. Everything's like to be determined. Temporary motion for depositions to be conducted by defendant under a pro se attorney, title and position ordered by the judge and the court. So imagine Sarah Boone conducting depositions. How is she going to do that? Are these people going to come into where she's at to do the depositions, or are they going to meet somewhere where it's like kind of like a neutral ground? Like, I don't know. All this is going to be really crazy and very, very interesting now that she's going to be representing herself. But, maybe she has an assistant from someone else and they can help her do some of this. I was thinking maybe the judge will grant that. Maybe. All right, y'all. So Sarah, yeah, a lot of people made a lot of jokes about that maybe her standby attorney will be DB. No, DB, we don't want him to be in here. Okay, DB was a hot mess. when I'm watching a trial, I just want it to be clean, you know, and you know, a lot of trials, there's a lot of hiccups and stuff like that, but I don't want them representing themselves. Okay. I just don't, because it's things are longer, things are more delayed. They usually don't know what they're doing, and they have to waste a lot of time explaining things to the defendant, like, oh, you're supposed to do this, XYZ, blah, blah, blah. And like, I don't know, it's just like time consuming. I'm like, let's just get on with the trial. But it seems like, you know, the judge was like, nope, Sarah Boone, this is all you. You're going to be taking care and handling all of this. Oh boy. So let's listen to, shout out to, I think, Court TV. I think they were the first ones to post it, because I've been waiting for someone to post today's hearing. I did hear there was a hurricane that touched down in Florida. So I wasn't sure if there's going to be any issues with that, if we're going to get any footage or anything. She's screwed. I mean, it's going to be really tough for her. So let's watch. And again, thank you to Court TV. And hi, Disaster. Hi, Steve. How are you doing today? Hi, Storm. Chasing Sky. Hello. Everyone in the YouTube chat. Hello, hello. How are you guys doing? I'm sorry if I missed some of your guys' message. I was just trying to get to the intro really quickly. Usually, I'm pretty good with getting to the chat. Anyways, hello. Try to boost the audio up. Here's Ms. Boone coming on in. Let me know if I need to adjust the audio a little bit more for you guys. Hey, Nicole, Christine, Patty Cat, hello. Diet Coke. Oh, Diet Coke. Oof. I'm okay with Coke Zero. Diet Coke is, can't get with the taste. Hi, Kurt. How's it doing today? So at this point, you know, they're working on how she's going to get her discovery, her getting a laptop while she's an inmate, and her working with this private investigator company. Now, the judge is going to address the motions that she put in. Now, what's interesting is that there was a response by JAC, and JAC is usually the one that handles like the financial stuff, like they approve the rates of the experts that you're going to hire, or like, you know, how to do like paying things out for like depositions, because things cost money when you do all this stuff, right? It costs money, so you need to make sure you have someone that oversees it. So JAC did respond, and JAC is like, well, I don't understand why she's asking for a, you know, standby appointed counsel when she technically forfeited her right to that. So we can't really do anything about that. The judge already said she forfeited her right to have a counsel. So I was trying to see if the judge maybe will change his mind. Hi, lady. How are you doing today? How's it going? I don't know if anyone responded to her ad. I mean, she's appearing in court right now. I don't see an attorney sitting next to her. She's got her pink handcuff on. I personally would rather have her have proper representation, but I mean, with how we've seen her in the letters, how she blasts these attorneys professionally and personally, I don't know if anyone's gonna be willing to step it up, you know, and do this for the glory and fame. Hey, what's going on, Richie? How are you doing today? Yes, she does have a pen. I don't know. I'm gonna suspect there's gonna be a lot of arguments between her and the judge. And I wonder if she's gonna get personal with the judge. If she's gonna accuse the judge of certain things. Like, oh, are you taking payment again from the news? I don't know. Maybe she's like in an all-women's place and they just have pink handcuffs. You know, initially I thought they were silver, and I thought it was just reflecting off something nearby that was pink, but I think they are pink. I wonder what letter she writes to herself as an attorney look like. Is today a holiday? I don't think so. I don't think so, Big Zebra. Have y'all seen the body cam police showing up when she just wanted to scare him with an arrest? She came bounding out the front door like they were there for her 7th birthday party. Who? Sarah Boone? Yeah, Sarah Boone's body cam footage was pretty bad. Interview footage, very bad as well. And to top it off, I mean, you have the camera footage or cell phone footage of her recording George Torres.
Case number 2020 CF 2603, the state of Florida versus Sarah Boone State.
Okay, looks like court started.
Will you take the seat?
Ms. Cohen, raise your right hand to be sworn, please. Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God? Yes.
Ma'am, good morning. Could you please state your full name and date of birth?
Okay, I'm gonna have to boost this up a little bit. Give me a second. The audio's kind of low.
For the record for me.
Sarah Boone, 101077.
I do see that we have a representative from JACS that's appearing virtually. Sir, can I get you appearance for the record as well?
Yes, Your Honor. Christian Lake with the Justice Administrative
Ooh, okay, hold on. I gotta readjust the audio here. Depends on who's talking. The audio's a little bit crazy.
Commission.
Okay, very good. All right, we've got a couple of things that we're going to be addressing this morning. The first is the motions, Ms. Boone, that you had made reference the last time I saw you. The court has reviewed all of those motions. I've reviewed also JACS's reply, specifically their response to the motion seeking due process costs that was filed on July 30, 2024. State, have you had the opportunity to review all of Ms. Boone's motions?
Yes, Your Honor.
Okay, all right. Ma'am, I want to go through each one of them and hear from the state, from yourself, and from JACS. We're going to start first with y'all can be seated, you don't need to stand, thank you. The defendant's temporary motion for reservation of proposed costs to acquire an investigator for defendant's defense and trial dated July 18, 2024, received July 29th. That request seeks to reserve any and all costs proposed to be incurred to acquire investigator. The defendant's temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense and trial dated July 18, 24, received July 29th, 2024. The request is to reserve any and all costs proposed to be incurred to acquire all witnesses for trial. And then defendant's temporary motion for depositions to be conducted per FRCP Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court dated July 18, 2024 and received July 29, 2024. I have reviewed all of those motions. All three motions reflect to be determined or TBD with regard to the investigator, witnesses, and deponents. The total amounts are to be determined. How to calculate is unknown. As for the depositions, the date are to...
And like I mentioned, at this point, she hasn't had her discovery yet, so that's why I think she put a lot of like to be determined, because she doesn't know what she needs to... I guess she doesn't know what angle she's going to go with, maybe? Unless she has her discovery in hand, but I'm sure she's already reviewed it with her attorneys. No? With Patricia Cashman? Someone?
To be determined, and the amount of transcripts are unknown.
Unfortunately, because this video is newly uploaded, there are no closed captions for court TV. Now, what happens is, I don't know if you want to rewatch it back, but you would have to wait a good couple amount of hours. This is like I don't know how long this is, but you have to usually wait for YouTube to fully like transcribe and do the video stuff, and then the captions will be available. But unless it's a live stream, captions won't be available. And unless the video's been up for a little bit, it won't be available, unfortunately, because I like having the captions too.
Mr. Lake, I've reviewed your response. Do you have anything else to add, sir, with regard to those items, investigators, witnesses, or deponents?
Not really, Your Honor. The only thing is, we can provide Ms. Boone a copy of our pro se packet that has information about, including model motions. We would be happy to send her a copy, or to send your JA a copy that you could send to give to her. That might help her for purposes of future motions. But as far as these are concerned, I think our response pretty much outlines what our position was as to each of those requests.
Okay, thank you.
Yeah, give her the pro se packet so she can at least have some guidance on what she can do. Because like she's putting all these motions in, and then JC is like, well, this is actually not the right way to do things. You have to come through us, and then blah 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 blah. And so when she probably got that response, she's probably like, well, I don't know how to do any of this. This was done today, a couple hours ago.
Thank you, sir. If you would be so kind to send that to Ms. Barrios, we will ensure that Ms. Boone gets a copy of it. State, do you have any position with regard to those three motions that the court just identified?
No, Your Honor.
Okay. All right, ma'am. So previously, Prison Break Investigations was already appointed to be your investigator. The JAC has no objection to authorizing $5,000 in costs for Prison Break and for $500 for obtaining case-related documents and materials on your behalf. So seeing as there's no objection, even though you were asking for a reservation, I'm going to go ahead and permit that cost to be incurred. With regard to the costs for witnesses and the depositions, you are requesting, as I identified earlier, just to reserve those costs. And as I had said earlier, the motions do not identify who the witnesses are or what the deponents are. So I'm going to deny those motions with prejudice, but that means you can refile them and we can readdress them when you file motions in the future addressing any of those items for ensuring witnesses being subpoenaed or appearing for your defense at trial, or for any persons that you may seek to depose. Because as of right now, I don't know who it is that you're seeking to depose based on your own motions. Do you understand the court's ruling as to those three motions, and do you have any questions, or do you want to add anything?
I would like to add, please.
Sure.
With your delegated due date of July 22nd, for all of my pretrial motions to be submitted, I have yet to receive my discovery, so I was trying to beat that deadline or at least meet it. So I don't know what I'm supposed to ask for, or who I'm supposed to ask for, and again, I have yet to receive my discovery, so I don't even know who it is I need.
Yeah, and that makes sense because remember, when the judge forfeited her right to have an attorney, he was like, okay, well, you forfeited your right to have an attorney. And by the way, all motions have to be filed by July 22nd. And as July 22nd was creeping up, she didn't have her discovery at that point. So that's probably why she was just like, okay, well, let me just write these motions out just so it's on the record, and we'll figure out what happens with that.
So I understand for those, so you're telling me at a later date once I have that information to revise them.
I'm giving you the opportunity to refile. Yes, ma'am.
Thank you.
With regard to the defendant's motion for reservation of proposed cost to, With regard to defendant's motion for reservation of proposed cost to acquire expert witnesses for the defendant's defense in trial dated July 18th, 2024 and received July 29th, 2024. Mr. Lake, anything else to add other than what is identified in your response?
No, Your Honor. Again, the issue here is, with the exception of the mental health expert that's already been approved, there would need to be much more specific motions for these costs. Ms. Boone needs to include essentially what we included in our response. And again, the model motions that we will be sending to will have that information. Without specific information, neither us nor the court can make an informed decision on whether the requests are appropriate.
Okay. Ma'am, the motion fails to identify any specifics. It has to be determined for your expert witness or witnesses. It does not identify the type of the witnesses. It doesn't identify the amounts. And it's difficult for me to identify the particular showing of need, which is what's required for the appointment of that expert. So,
and her response is going to be, I don't have the discovery yet. But it seems like we had a preview of what potentially her defense was going to be, at least with other previous attorneys. I think they were going to go for the battered wife defense. I just don't know if she didn't agree with that, or she did agree with that, or maybe she wants to take a different approach. We don't know what happened between her and the previous attorneys.
again, I'm going to give you the opportunity to refile in the future a motion pertaining to any specific experts identifying the specificity that JACS has requested in their response. So at this point in time, that motion is denied without prejudice, and you'll have the opportunity to refile it. Lastly is the defendant's motion requesting immediate relief to the defendant by appointing effective standby counsel to aid in support and preparation of a criminal case.
Oh, this is the big one right here, because I was thinking maybe the judge will give it to her. Again, she's not asking for someone to represent her, but she wants to have a standby counsel to kind of assist her throughout this pretrial stuff and during the trial itself.
Case for trial dated July 18, 2024, and received July 29, 2024. The request, ma'am, that you were seeking in that motion is to provide immediate relief to defendant by appointing effective standby counsel to aid in support and preparation of her criminal case for trial. State, do you have any position with regard to Ms. Boone's request for standby counsel?
What do you think they're going to say?
No, Your Honor, other than what's already been placed on the record in the court's order.
Okay.
Okay.
Mr. Lake, anything over and above what's in your response?
Just briefly, Your Honor, the point we would make, Your Honor, is I think Ms. Boone misunderstands the role of standby counsel. Standby counsel is not co-counsel or assistant counsel to a defendant. Standby counsel is there for when, in the situation where a pro se defendant who is elected to represent herself decides at some point they want a
Okay. That I didn't know.
situation where a pro se defendant who is elected to represent herself decides at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who is asserted to represent themselves decides at some point they do no longer want to represent themselves, the court has a lawyer already in place so that the progress is not delayed. It is not an assistant or a co-counsel. It is someone whose role is essentially not to get involved until the defendant says, I no longer want to represent myself.
Okay, so he said that it's someone that elected to become to assist them, to represent themselves. As we all know, Sarah Boone does not want to represent herself. She wants to have an attorney. And, you know, she's said that she's had ineffective counsel, blah, 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 complaining about all the previous attorneys who've tried to help her. Now, he's saying that, like, oh, you only get a standby counsel if you elected. So you yourself chose to represent yourself. And then you just have a standby counsel just in case, you know, I guess shit goes wrong, right? Now, in this case, you know, the judge has forfeited her right to have counsel. So that's a different scenario. That I didn't know.
Ma'am, the court's had the opportunity to review the case law on this issue. There is no constitutional right to stand by counsel, as decided by Paul v. State, 152 Southern 3rd, 635, at pinpoint 641 by the Florida 4th District Court of Appeal in 2014, citing to the Florida Supreme Court case in Jones v. State, 449 Southern 2nd, 253, at pinpoint 258 from 1984. As the court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel, the court is not required to appoint standby counsel. And that's Brown v. State, 45 Southern 3rd, 110, at pinpoint 114 through 115, Florida 1st DCA 2010, citing to, again, Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se and with legal representation by the Florida Supreme Court in 2009 in Shepherd v. State, 17 Southern 3rd, 275 and 279. For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied.
Yikes. That's a huge blow to her.
Do you have any other questions, ma'am, as to the court's rulings this morning?
First off, I did not forfeit my rights. That was your judgment. And also, I feel that
just a warning. I'm going to boost her up a little bit, but when the judge starts talking, it might be really loud. So I don't know. Just be aware of that. So I'm going to boost her up if that's okay. It's kind of hard to hear her. But like I said, when the judge starts talking, he's going to be a little bit loud. So give me a second.
First off, I did not forfeit my rights. That was your judgment. And also, I feel that I should have had some type of evidentiary hearing prior to your decision, so I could have better explained myself and you could have had a better understanding. So by you denying my standby counsel, which thank you to him for explaining to me what specifically it is, I don't want to be pro se any longer, so I didn't want to be pro se in the first place. And again, you, in my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy so you would understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity, or if it's just something that is denied, period.
It is denied.
And so she has written that in her motions. I think in her motions, right? Or at least one of the motions that like, oh, I didn't forfeit this. I didn't forfeit this. I wanted to have someone represent me, but they're just ineffective. Judge, you're the one who made this decision. Yeah, he made the decision that you forfeited your right because of how, I guess, all the issues between you and your previous public defenders.
Period. With regard to an evidentiary hearing, that seems to be in the realm of a Ferretta inquiry where a criminal defendant is seeking to represent themselves. And I would inquire of that person and have an evidentiary hearing as to the rights and remedies that you were forfeiting and the pros and cons of proceeding representing yourself and the benefits of being represented by counsel. Due to the Florida case law that was provided in the 16-page order, no such evidentiary hearing is required.
My understanding was the hearing, the Ferretta hearing, is in regards to competency as opposed to having an understanding before you take someone's rights away.
Ferretta pertains to a criminal defendants seeking to represent themselves. Ferretta was not applicable to your situation, and that's identified in the case law citations that were provided in the 16-page order.
Yes, I understand. It was the day of that I was explaining most of all of this, and as opposed to prior, so I would know what happened or could happen. So my understanding is one thing, and then the explanation is another. So I'm just confused and feel that I should have had an opportunity prior to all of this to explain myself and to have a better understanding. So now my belief was that the Ferretta hearing was simply competency. So the evidentiary hearing I thought would be a collaboration of the information of why I wrote my letters in order for you to remove my rights counsel. That, in my opinion, I felt that it was a type of retaliation by the court because you did not understand or attempt to understand any of my letters that I wrote previously, which was for the intervention of the judge and or the court, to avoid any of this with me sitting in front of you present.
Ma'am, as identified.
Wow, she said court retaliation. So she, I guess, she wanted an evidentiary hearing of some sort, where the judge explains to her, okay, you have forfeited your right to counsel, and then she's going to argue her side. She just feels like it kind of just happened, and she didn't have a chance to really like be heard out, I guess.
In my 16-page order, I listened to every audio hearing. I specifically provided dates and times and words that were specifically said at particular hearings involving yourself and prior counsel. I also made reference in the 16-page order to statements that were made in your letters. I promised you.
Yeah, that's a strong phrase right there. Court retaliation. Oof.
Okay. I believe, in my opinion, the order is erroneous, and after I reviewed your 16-page order, there are quite a few incorrect entries, and some of them are based on perjury by the attorneys. And by you reading and then also listening to the audio, you did not listen to me in any way, shape, or form in order for me to explain myself better, so you have an exact understanding of the particulars of each letter for each attorney.
I'm not going to revisit my prior decision.
I understand. I'm just trying to make you aware that is my opinion.
You, and like we talked about last time, ma'am, you're certainly entitled to that opinion.
Thank you.
All right. My judicial assistant has been in contact with the representative from the Orange County Jail, Sergeant Donald Casey, who is on his way in order to facilitate the transfer of the USB drives from Prison Break Investigations. I do see that Mr. Lane is present. So as soon as he gets here, we'll be able to address that exchange. What we can do while we're waiting for that representative to appear is address some of the things that were identified in the notice of hearing for today, which is kind of a scheduling conference for when we might be setting up certain deadlines. As of right now, the trial is scheduled for October 7th. The trial will be extended from 2 weeks to 3 weeks.
I actually wasn't, I thought she was going to put in a motion for a continuance. Because, like, you know, her argument would be like, oh, I haven't gotten my discovery yet. I'm not going to have enough time to prepare. I don't know what I'm doing. Everything's going to go on fire. But yeah, she didn't put in a motion. She did not put in a motion for continuance. I thought she would. Maybe she'll do that next. You like the judge so far? Yeah, he seems like a no-nonsense judge, straight to the point. And then when he's explaining things to her, he's like, do you have any questions? Let me know, or anything about the process and stuff like that. So
the trial will take place on October 7th, October 14th, and the third week of October 21st. October 21st is not this division's normal trial week. However, the court has obtained coverage for that week so that should this trial proceed into a third week, we will not have to scramble in order to find coverage, and that we'll be able to efficiently proceed with any evidence or testimony on that third week on October 21st.
the audio is cutting in and out. My microphone, or is it this audio? Is it the judge speaking that's cutting out, or is it my microphone that's cutting out? I don't know. It's not cutting in and out for me. Is it cutting out for anyone else? I can listen back to the VOD. On my, yeah, I don't know. It should be fine. I guess it sounds fine on your end. Oh gosh, this is so hard when it's like some people are saying yes, some people are saying no. Seems fine to me. Maybe it's my, let me see. I don't think I have my noise gate on. What about on Twitch? Is it cutting out for you guys too? It's cutting out on your iPad. Oh, it was cutting in and out. You did a restart. It's fine now. Was it cutting out earlier? It's fine for me. Oh gosh. Okay, let's try to proceed, and then just let me know how it is. I'm so sorry, guys. The court audio is high and low. Oh, okay. So yeah, so I've been trying to adjust the court audio up and down as I'm going, because Sarah Boone's audio is very, very low in comparison to the judge and the JAC person that's on the screen. So I try to tweak it up and down, up and down.
Pre-trial was scheduled for September 24th at 1:30. The court typically has its regular trial case managements on that Tuesday. Due to Ms. Boone representing herself and some of the complex issues that may be involved in this case, I'm inclined to change the date of the pretrial so that we might be able to have our own pretrial separate and apart from all the other cases that may be set for that same trial period. My thought would be to move it to, rather than the Tuesday the 24th.
It's better now? Okay, so if it does sound bad on the live stream, typically what I'll do is I will edit the videos where I kind of take out any of the like banter chatters and stuff like that or off topic stuff. And then I condense it to like the video where it's just like straight to the point. If the audio is wonky on that one, I will fix it. Hopefully it'll be okay. And yeah, so usually that's what I do. I make like another video and hopefully it'll be okay and fixed on there.
4th to Tuesday the 26th, separate to Ms. Boone representing herself and some of the complex issues that may be involved in this case. I'm inclined to change the date of the pretrial so that we might be able to have our own pretrial separate and apart from all the other cases that may be set for that same trial period. My thought would be to move it to, rather than the Tuesday the 24th, to Tuesday the 26th at 9 a.m.
Is that Thursday?
Yes, sir. That's Thursday.
That's acceptable to the state.
Ms. Boone, that would give you additional opportunity to prepare for trial as well. Are you amenable to changing that date to September 26th at 9 a.m.?
So an additional 2 days?
Correct. You would still have that time to prepare regardless if we had the hearing on September 24 or September 26. I'm just moving it so that we don't have 50 or 60 other cases and I can focus more attention on your case specifically.
Of course.
Okay, all right, so pretrial will be rescheduled till September 26th at 9 a.m. One of the issues that I wanted to address was deadlines for production of the state's exhibits and the defendant's exhibits. Now, I'm mindful, Ms. Boone, that you have not reviewed some of the documents that may have been provided. I know most recently, Ms. Cashman spent 20 hours with you alone going over questionings and reviewing some of the materials. I don't know the breadth and scope of what was reviewed to you, but some of it
That was the previous attorney.
may have been reviewed to you based on counsel's representations. State, I want to address with you first, because Ms. Boone hasn't reviewed the discovery yet, as to what your position is with regard to assembling or finalizing an exhibit list or your exhibits for trial.
As far as providing a list of the specific items that the state seeks entry of?
Correct. I do want it before pretrial. So let me just kind of lay the map for what the court's thinking. The court would have the state provide a exhibit list and a witness list by X date. Ms. Boone would have the opportunity to look at that list. We would then have a hearing where all of the exhibits would be shown to and provided to Ms. Boone. They would be provided on a USB thumb drive. They could be utilized with a laptop at the jail. And then she could view all those exhibits here in open court. And then she would be afforded the opportunity to make an objections in writing to any exhibits at a later time by a certain date.
I guess one of the concerns would be that if the state identified specific items that we would seek entry of, depending on the course of the trial and the questioning, there may be other items that have already been disclosed in discovery that may necessitate being entered in, that would potentially not be part of this original witness exhibit list. Items that were in the discovery, but if that makes sense to me.
That does make sense,
Yeah.
and I understand what you're saying. And that seems to be more of a fluid situation as to what may happen at trial, right?
Sure. I don't imagine the court's intent would be for the state to just produce the exact witness lists that have already been sent in discovery and just make a notation of every item of evidence.
Ooh.
The idea would be to try to pare down.
That's exactly the idea. Now, obviously, that wouldn't
They heard y'all talking about the trench coat. They're like, here, I got you. I'll zoom in for you. I think there's a hurricane happening right now in Florida.
foreclose you if something was produced in discovery and something that would not be relevant or admissible at a certain stage of the trial, but maybe later became relevant or admissible due to something that happened or something that was said. I would not foreclose the state, nor would I foreclose Ms. Boone from attempting to move that piece of evidence into evidence for the jury to consider. But it would be almost like a civil conference where you and opposing counsel would go over what your exhibits are prior to proceeding to trial. And I think that's important to do that so that Ms. Boone has the opportunity to view those in court so that's on the record as to what she's reviewed, and then give her the opportunity to provide any objections, if any, to any of those exhibits. And again, I wouldn't foreclose you if you want to use items A, B, and C, and that's all you intend on using. I don't know what you intend on using. I don't know what evidence you have. If you only want to use and only show A, B, and C, but are saving D, E, and F for later, depending on what happens, I won't foreclose you from readdressing D, E, and F. But it's just an opportunity to address what it is you think you're going to be seeking into evidence at this time.
So essentially,
Is this Mr. Cacciatore? There's been so much focus on Sarah Boone that I don't even know what the state looks like.
Go ahead, sir.
so I think we could accommodate that if we could go around September the 1st for that, and then that would give her an opportunity to review that USB and lodge any objections, and then we could potentially address those objections and go from there.
Okay. And that would be September 1 to have the evidence viewing, for lack of a better word, or for the list to be provided?
For the list and the USB.
Yeah, we're going to make this work for an October 7th trial date, Judge. I think September 1st is probably about the right time frame to have this in-court hearing to begin lodging those objections if she has any. My next question is, are you expecting the physical evidence to be brought here into court by a CSI so that she can potentially open it? Or are we just talking about digital evidence and giving her a list of the physical items?
If there's physical evidence that's sought, I want her to have the opportunity to review it.
And we should be looking at the top of the month for September so that we can get this done.
Okay, all right. Ma'am, do you understand that what it is that I'm discussing right now, so that you have the opportunity to review the evidence that the state may be seeking into evidence in your trial?
Is it my understanding that they will supply me with a USB drive, and then I am to review it while in court?
No, ma'am. So it's kind of a two-step process. So anything that's digital, that's not forensics or CSI or something that's tangible, will be provided to you on a USB drive. We also will have a hearing where all of the evidence, including any digital, electronic evidence, or any tangible evidence, CSI materials, will be shown to you in court, played to you in court, so you have the opportunity to review it here as well.
And I believe the judge did outline how much time she will have on a laptop. I think he worked that out with the prison, I guess. Wait, hold on a second. What did he say again? It was like, I think she would have like from 8 to 5 that she'd be able to have like in physical, she'll be able to physically be able to use her laptop. So they'll give her a USB. She'll get to review it from 8 to 5. Or is it like, it was like, was it 8 to 5? 8 to 5, 9 to 5, something like that. And then what he's saying is like, oh, we'll have an in-court hearing about, if you have any objections. Was it 8 to 4? It was 8 to something.
Anything else will also be given to you on a thumb drive.
Sorry, I always mix up prison and jail. And I think that's why my mind was like, jailhouse.
For you to review at your leisure based on the hours of 8 to 4 by the laptop at the Orange County Jail.
Oh, he said it right
Then
there.
we will have
Okay.
a deadline after we have this evidence viewing for you to identify in writing any objections that you have to any of the evidence that's been provided by the state.
So it's not a matter of any type of confidentiality? It is all done in the courtroom with everyone?
It would be in the courtroom, correct?
Are there going to be news cameras and photographers?
That's something I need to address. I do not want, because our jury pool is going to be coming from Orange County, I have concerns about the media's presence in the evidentiary viewing. So I may have to enter an order which would prohibit media access for the purposes of that hearing due to the nature of what is being produced and reviewed, so as to further prevent intimate details of the case being released prior to trying the case.
Could be fair. Okay.
I understand that, Judge. Ms. Boone, not to turn the page completely, but I think it's pertinent to this discussion, has indicated through some counsel that had met with her recently that she wants to talk to the state out of the jail, and I was going to discuss that at the end, but perhaps to not waste the court's time, I don't know about bringing physical evidence out to the jail, but as far as the digital evidence, which will include autopsy photographs, which will include crime scene photographs, which will include videos, perhaps a different suggestion, especially since she has an investigator from prison break, is that we identify those files that we intend on introducing at trial so that they can review that digital evidence on their own in the jail, and we're not publishing all the digital evidence here in open court. That should allow her the opportunity to lodge any potential objections such as duplicative or any other objections she may want to raise about autopsy photos, so on and so forth, without exposing all of the digital media to the public. As far as the physical evidence, the state doesn't have any real concerns about the media covering that. She can open those exhibits, or somebody with scissors can open those exhibits for her if there are any exhibits she wishes open in the witness box where it's concealed from the media's eyes. So those are my suggestions, and then later we can turn to her request and we can put on the record how we would go about going out to the jail and meeting her.
The only concern that I have with that is I don't have a record as to what it is that she reviewed.
My suggestion would be that because this is in the context of plea negotiations potentially. I would be out there, Mr. Cacciatore would be out there, and our investigator would be out there, and we would record it.
I believe this is in Orange County in Florida.
The conversation that we have, of course, and that would all be protected because it would be in the spirit of plea negotiations under the evidence code. And then we can all file in writing, the state can file in writing, these are the videos that we are going to use. These are the particular photograph numbers from the crime scene and from the autopsy photographs that we're going to use. And then we can have the defendant sign off on that as well, so that it's documented as to what was told that she would be facing at trial. And either she can review it with her investigator or she can review it with us, being present, and then that way the digital evidence is now in the open.
Okay. Ms. Boone, what are your thoughts on that?
I'm a little lost. So it's an option of reviewing what the state has with my investigator and then be able to come with the objections and everything?
That is
So
correct.
I'm clear on having all of my evidence being in sealed bags and for me to be able to inspect them to be here in the courtroom. I don't know how the attorneys have done any of this prior, but I don't believe that it was in the courtroom. So I'm just trying to protect myself against the media. I'm not sure at this point what is even suppressible that is available on the internet. But at the same time, though, it is my understanding that I should have some right to privacy in reviewing the evidence. So I didn't know if my investigator and I are able to collaborate prior and view and then come to court with everything finalized and ready to go with answers.
I'm certainly going to give you an opportunity to meet with your investigator to address it. The question is just the method of how to do it. The state's proposal is digital. They would meet with you, identify specifically digitally what videos, what photographs they intend on utilizing, and anything that may be physical, CSI, etc., would be addressed here in open court.
And just so the court...
And I think the judge already said that for the evidentiary stuff, I mean, he's going to consider not having the media there.
The defendant understands how physical evidence viewing would operate normally. The defense attorney and or her or his investigator would come out either to the sheriff's office or OPD's evidence center, whichever agency, and they come and view it, but it's done in the presence of the state, it's done in presence of law enforcement, it's done in presence of the CSI for the chain of custody. So attorneys don't get privacy when they're reviewing the physical evidence either. So that wouldn't really be any different than if she's doing it in the witness stand or wherever we deem suitable in the courtroom.
I think that's the most appropriate way to have the opportunity, ma'am, to review the evidence. I can't release that evidence to Mr. Lane to bring to the jail for your review because of the chain of custody issues concerning some of the physical evidence. So CSI would have to be here just like an evidence viewing at the sheriff's office or elsewhere where counsel just identified. And I cannot bring you anywhere else other than here, and I can't release you to anywhere else. So I think the only solution that we have is to have the evidence viewing here with regard to any of the physical evidence.
Oh, this happened back in, I think, like early 2020, right before the pandemic happened. The guy in the screen, I believe they're with JAC, which is, I had it up here, Justice Administrative Commission.
Why is it that it cannot be transported anywhere other than here?
Because I cannot make a record anywhere else of what you saw or what was reviewed. The only opportunity for me to make that record is here in court.
What did prior attorneys do?
That was already identified by the state.
I know I'm trying to keep up with everything. What was the answer, please?
So an attorney who's doing an evidence view would come out to the law enforcement agency's evidence warehouse, for lack of a better term, and then in the presence of the state attorney, the CSI, and the lead detective, they look at the package, and if they deem any particular package worthy of opening and examining, they can do that. We can have the CSI bring butcher paper here so that any particular item can be opened, put on fresh butcher paper, and then changed out between exhibits so that there's no contamination.
See, this is why I want her to have representation, or I prefer that. I know a lot of people are like, yay, she's going to represent herself. It's going to be a shit show. It's going to be entertaining. I'd rather have her have a representation because it's going to be a lot of this happening in court where she won't know what's going on. They're going to take time and then explain things to her. Maybe that's why the judge initially went from doing 2-week trial to being, hey, it might be 3 weeks actually, because maybe he's also including time where they're going to spend, I say wasting, but they're going to have to explain to her certain processes along the way as well.
And then you can examine it. If Mr. Lane or any other representative from his organization is here, he will have the opportunity to photograph those exhibits once taken out of the packages. And that's essentially how an evidence viewing is conducted.
Thank you.
You're welcome.
And again, please, would the media be involved in that?
That's a conversation that I need to see if I can exclude them from participation or viewing that proceeding.
You said that earlier.
There are rights where the media has to view proceedings in court, but due to the sensitive nature of what may be being discussed or viewed, I need to see if I can prevent media access. So without doing a little bit more further dive of research in that, I don't know if I can make that call at this time.
Yes, I have not heard of a case where the evidentiary hearing has been televised. So, if you could please look into that, because I disagree with the media being involved in that.
I understand your position, and again, for the reasons that I stated earlier, I'm trying to prohibit as much as I can from dissemination to the public, especially some of the exhibits that the state may be seeking to utilize. We are going to go ahead and set the evidence hearing. The first is Sunday. September the 1st is a Sunday, and that is Labor Day. The court would be setting a hearing for Tuesday, the 3rd at 9 a.m. to have the physical examination here in court. At that time, the USB drive or the after our viewing here in court, stays at your position to then have that meeting with Ms. Boone and her investigator and your investigator under the plea negotiations or settlement discussions auspices to review all of the digital and identify what it is specifically?
We are happy to defer to the defendant's wishes on that, and I wanted to have that discussion. It seems like we're turning that discussion. So I'll leave it in Ms. Boone's court. My indication from one of the attorneys that she had discussed things with said that she wanted to have a conversation with us, and so I'm offering that up. In the past, with female defendants at the Orange County Jail, there are classrooms, or at least one classroom there, where we could arrange to meet. It would be a big enough room for 4 or 5 of us that would need to be there. And then we can discuss that, whatever it is she wants to discuss, and it would be recorded. And again, those portions of the conversation that are about plea negotiations and the evidence and whatnot in the trial, I believe under the evidence code would not be admissible to be used against her. And I leave it to her when she wants that to happen. We can make arrangements to try and accommodate that. It should not take us very long at this point, given the age of this case, to select and identify which digital evidence exhibits we're going to use. It's simply a matter of getting rid of duplicative and irrelevant photographs from the scene and the autopsy. And I believe the videos won't be too hard to decide which ones to use. I don't know that there's a whole lot of other digital evidence.
Okay. All right, ma'am, do you have a thought on when you would like this viewing to take place at one of the classrooms at the Orange County Jail under the concept as identified by the state?
So this meeting is separate. This is prior before everything else.
What I would envision, to not waste anybody's time, is we can go out there and have this discussion, if there is a discussion to be had about plea offers. One of the other topics was other matters, so that's kind of ambiguous. I'm not sure what other matters are. And then also we can let her know and probably provide the court in writing a list of the digital evidence that we seek to introduce. And then that way, if she wants us to review those digital evidence items together with her in the presence of everybody, we can do that. Or we can let her, with the list of the digital evidence that we plan on introducing, review that as many times as she wants by herself and or with Mr. Lane.
I understand. So would I be leaving with the digital evidence today, or how soon may I receive that?
So the state needs to assemble that. So my thought would be to have that meeting, ma'am, on the 3rd of September. So we would have a hearing at 9 o'clock in the morning where the physical evidence would be reviewed here in the courtroom. As soon as that evidence was finalized and reviewed, the state with their investigator, yourself with your investigator, would then meet that afternoon at the Orange County Jail to address, as the state has identified or spoken about, any settlement negotiations, plea offers, and under the other category to address what the digital
plea offers. You think there's any plea offers on the table for Sarah Boone?
exhibits are. They would provide you those on a USB drive, and they would identify for them specifically what it is that they are seeking for you to review at that point in time and have the ability to review it afterwards.
We're happy to do that beforehand, and I just want clarification. By providing her the USB with all the narrowed down exhibits out of discovery, are we providing it to Mr. Lane? How are we physically?
It would have to be provided to Mr. Lane,
okay,
who would then have to provide it to a member of the staff at the jail, the names of which I have from the captain at the jail as to what persons are involved in the laptop process. And then once that's done, I would require Mr. Lane to identify with a filing in the court, probably in the form of an affidavit, as to when, where, and how the USB drive was received by him, and when, where, how, and to whom it was delivered.
Thank you.
Your Honor, I feel uncomfortable with you all supplying my evidence to the jail. So I don't know if there's a way that, I don't know if you are aware, but my jail phone calls have been released, and there's a lot of things that have been released from the jail.
Her jail phone calls have been released? I haven't heard of that.
So I don't know, I do not feel protected by you all handing it to the jail. I know that Mr. Lane and I previously had worked on the laptop with USB drives that he has furnished himself from bringing in from the outside. So I didn't know, and I would feel more comfortable if there was a process or a procedure. I don't know who your names are from the jail. I do know the captain, whom I spoke to the other day regarding my laptop. But I would very much...
Who was that, ma'am?
I'm sorry?
Who was that?
For which?
The captain that you spoke to. Who was it?
T. Giovanni.
Okay.
There's multiple sergeants involved, and I did meet the gentleman who was supposed to be here today to pick up the USB drives. So I don't feel comfortable, please, with providing the USB drive of my evidence with things that have been leaked or released from the jail. So if there's a possibility, please, I would like for my investigator to have that and bring in with me prior.
If I understand the jail's protocol, which I read to you at our last hearing, the jail will keep custody of the USB drives and release them with the laptop as well. So I don't know how I can bypass that process that they've created, because the USB drives and the laptop, when it's checked out by you and when it's returned by you, is all going to be logged in their IMS system.
Right, it's simply a laptop. It's a very basic laptop where anyone affiliated with my case has any type of digital evidence they bring in with them from the outside. It's simply a basic laptop that we are able to utilize at the Orange County Corrections Department. That's how we have done that prior. So I don't know what it is different, and I don't know the jail protocol because no one's included me.
You were provided a
He told her last hearing.
copy of it through the court filing, and I read it to you at the last hearing.
Yes, he did.
Your understanding is different than my understanding because my contacts from the jail are telling me something different.
Who? What are their names?
There's multiple sergeants.
What are their names?
I'd rather not get them involved with fear of harassment or anything from other...
Ma'am, I'm deferring to what the Orange County Jail and the captain that you identified specifically as to her memorandum to the court, which was read to you at our last hearing, which was sent a copy to you by a notice of service, and was provided by U.S. mail. It was sent out last week.
I have yet to receive anything such as...
Don't worry, I have a copy to give to you this morning, just in case you have not received it.
Yes, the last thing I have is your order that you provided me with the implementation of your USB drive option.
All right.
So anything that you are speaking of in the meantime, I do not know, and it was served by process,
It was served by U.S. mail.
by U.S. mail? Yes. I actually have 3 motions, please, if I may submit them to you.
In a moment.
Yes, in the process of, because the address that you are, I'm guessing, sending these to is incorrect.
I received your letter addressing the address issue. That's been remedied. So the appropriate legal mail address will be utilized. It was simply a clerical error, and that has been remedied. But regardless, I did read to you at our last hearing the protocol for the USB drive in the jail. The court is inclined to follow the Orange County Jail's protocol with regard to the USB drives. So the evidence, digital evidence that the state seeks to admit at trial will be put on a USB drive, delivered to Mr. Lane. That will be delivered to a representative from the Orange County Jail. And Mr. Lane will thereafter file a filing with the court in the form of an affidavit identifying when he received it from the state and who he gave it to, when he gave it to, and what representative of the jail he gave it to.
So it goes from the state to Mr. Lane to the jail.
For the purposes of indexing it, for the purposes of their records, under the protocol, and then it will be available for your use.
So if I want to see all of my evidence digitally, I need to contact someone at the jail.
No, ma'am. The evidence that were in the 2 bankers box that Mr. Lane digitized for you is going to be provided to the jail. That's going to be provided with the laptop to you. And that's available to you from 8 a.m. to 4 p.m. every day in the protocol that I read to you at our last hearing.
Yes, and I will speak to the captain just to be aware that everyone that it is in the process, because I do not feel comfortable with any of this, and I do not feel protected either by the courts or the jail system. So for right now, I don't know if it can be postponed or if it's something that I need to write another letter to. Everything takes longer in jail. So by me trying to get a hold of the captain nonetheless, it's going to be a feat in itself. So I want you to know if anything that...
Wait, so she wants to postpone the process of the USB going from the PI to the jail staff because she doesn't trust the jail, the courts. So she wants to... Is that what she said?
In the process of trying to be in jail. So by me trying to get a hold of the captain nonetheless, it's going to be a feat in itself. So I want you to know, if anything, that I am in the process of trying to reach out to the captain. I don't know if she'll be here today or if it'll be the contact person. So in the process, I am working on speaking to the captain because I do not feel, like I said, that I am protected in any way, shape, or form by the Orange County Corrections Service withholding my evidence in any way, shape, or form.
Okay. The court's going to follow the procedure as I outlined at the last hearing. So here's what we will do. We will, on Thursday,
So the judge is like, no.
September the 3rd at 9 a.m., we'll have a hearing to review the physical evidence. At that time, the state will provide its exhibit list, which will be filed with the court at that time, and a copy will be given to Ms. Boone of the physical and the digital evidence they are seeking to admit. After we have the in-court examination of the physical evidence, that afternoon, there will be a meeting at the Orange County Jail between the state, its investigator, Mr. Lane, Ms. Boone,
So now we're repeating again for like the third or fourth time.
to review the digital evidence and provide a USB drive with that information.
Okay.
Caveat in that order being, unless it hasn't already been done. In case we do it ahead of September.
Sure, if you want to do it before, the deadline to do it will be to September 3. But the in-court physical examination will be at September 3. So if you all want to meet in advance of that, I won't prohibit that. Just file something in the court file identifying a notice or some document so that it identifies when that meeting took place, when the evidence viewing took place. Okay, thank you very much. Ma'am, after we've had this hearing on September 3, and that being the deadline for the digital evidence and the viewing of the physical evidence, the court would then like to set a deadline for when you would provide your objections to the state's exhibits. Mindful that this will take place on September 3 and that we have pretrial set for September 26th, and if we need to have a hearing with regard to those objections, my thoughts would be to give you 2 weeks until the 17th to lodge your objections. And those would need to be provided in writing by
September
the 17th.
17th.
So that if there are objections and if we need to have a hearing on them, that hearing can be held when we have our pretrial on the 26th. That would give the state ample opportunity to prepare for any of the objections that you have.
Forgive me, and thank you for your patience, everyone. So on September 3rd, I will be viewing the digital and physical evidence here in the courtroom.
Correct.
And then later that afternoon, I would be meeting with the state and my investigator.
If they don't meet with you prior to that date. The deadline for the state's investigator, your investigator, and yourself to meet to review the digital evidence would be no later than the close of business on September 3. I've outlined for when I would like it done, but if the state wants to meet you in advance.
Maybe it's really hard for her to write notes when she's handcuffed. Because I feel like this is our fourth time going over this.
Of that date, they can do so.
Yes, please. If I may ask, please, what is your name, sir?
William J.
Could you spell your last name, please?
J-A-Y. Don't get asked that whole lot.
And what is your affiliation with the state?
I'm the homicide unit chief.
Yes, please. And I am okay if you would like to meet prior, so less time is consumed on the day of our meeting, supposedly on the 3rd.
So I assume you have availability. Should I meet with Mr. Lane to discuss his availability so we can get out there this month?
Yes.
Then you can do that. And like I said, Mr. J, if you could file that notice,
Yes,
just identifying when, that would be most appreciative. So, ma'am, understanding where we are with the viewing, what is September 17th for the deadline for your objections acceptable to you?
2 weeks.
Yes, and if I may please raise the point that I have a motion here in regards to, well, I'm in the process of working on it for the laptop. I do not have my discovery as of yet, and I do not have the laptop as of yet. I do not know what hiccups may be involved. There's a lot of hiccups with the jail already. So I'm trying to figure out when and where I'll be able to view anything. So there's a great restriction also that is being put on the laptop usage from 8 to 4. I'm unable to utilize my time to the full extent. Also,
I don't know. The audio is like weird. I'm gonna use the bathroom really quick. I'll be back in like 30 seconds. Ain't trying to get no UTI. I drink a lot of water. Okay, we're back.
So I have a motion here to receive the laptop usage from 8 to 4. I'm unable to utilize my time to the full extent. Also, I have a motion here to receive my hard copy evidence because when the laptops are in quote, the laptop is in quotes, closed for the day at 4 p.m., I can therefore pick up using the hard copy evidence.
I haven't had the opportunity to review the motions that you're speaking of. Neither has the state. We'll address them today. I don't have a problem doing that. I'm just not going to do it right this second because
That's right. She wants the hard copy. She argued that last time.
I haven't had the opportunity to review them yet.
Yes, and I'm just explaining myself in the meantime, please, so you're aware of what I have already thought of and am trying to ease the pain of everyone with me trying to figure out how to do everything and when and do it appropriately. But I just wanted you to know that by us agreeing on topic, I have that to also be looked over.
Okay.
Please. 917, if that has to be changed, am I okay to do that?
I'm trying to set deadlines now, ma'am. And that will give you 2 weeks to review the physical evidence. You'll be provided the digital evidence, it seems, in advance of that September 3rd deadline. And that may give you more than 2 weeks to review and lodge any objections.
I don't think she's gonna get hard copies too.
Correct. This is only addressing any objections to the evidence that the state seeks to
Unless, the jailhouse that she's staying at, unless they change their minds on their process.
admit.
The digital discovery, is any of that included in that?
Yes.
Okay. I am very wary to make any type of deadline.
Well, we're setting them today,
I understand. So the 3rd is a what day? Thursday?
Tuesday. So the 17th would be 2 weeks later, Tuesday the 17th.
And
The
that
judge is trying really hard to be very patient now.
my objection.
That would be you filing your objections in writing with the court. And to the extent we would need to have a hearing on those objections, we would have them when the pretrial or trial case management
Can someone just mail her the hard copies? Damn. The issue was that the storage is like, where are they going to keep this? They don't want to be held accountable for it. So that's why they're giving her the digital copy via USB for her to put it in her laptop. So they just don't want like the hard copy shit just laying around, I guess.
conference is set at 9 a.m. the following Thursday, the 26th of September.
I'm sorry, what is on the 26th?
That's when we're having our pretrial or trial case management to address any last minute issues regarding trial.
I'm telling y'all, this is a preview of how the trial is going to look like. It's going to be like this. We're going to repeat things over and over again, and then things are going to be unclear. Case management, September 26th.
Forgive me. So today being August 5th, I'm supposed to expeditiously complete my case that in every way, shape, and form by September 26th in order to go to trial for October 7th.
The dates are what the dates are. September 26th is the trial case management date, and October 7th is the trial date.
So by me not even seeing my discovery yet 2 days, and only being restricted to a laptop from 8 to 4 and not having my hard copy evidence.
You have 62 days to prepare for trial, not including today, and you're going to get your discovery today.
62 days, dude. That sounds like a lot, but 62 days? Oh, I gotta be sweating.
Wow. So in over 4 years, it comes down to me representing myself in 62 days.
I'm not going to answer that question.
Brandon, thank you so much for being a member for 19 months. Welcome back. Happy Monday. Hello, hello. I hope you're doing well. I just got here. Hi, Chrissy. How are you doing today? What is this hearing for? When was this hearing? This hearing happened today, a couple hours ago, and it's to address a lot of stuff, but to address the 5 motions that she had filed, maybe like a week plus, to address scheduling stuff, how she's going to view the evidence. So they're scheduling the evidentiary hearing, which is going to happen on September 3rd. There's going to be a deadline set for Sarah Boone in case she wants to object to any of the state's exhibit. That's going to be September 17th. And then September 26th, they're going to have a pretrial hearing, case management stuff. But I mean, she did have one of the major motions that has been denied was her requesting for a standby attorney to assist her. And the JAC person, which I believe is the person that's on the screen back there, clarified that Sarah Boone doesn't understand the concept of a standby attorney. He said that standby attorneys are for people who, of their own volition, decide to represent themselves. And then they want a standby attorney just in case, like things go wrong, and they want to have an attorney do the work instead. Sarah Boone, she didn't want to represent herself. That was something that the judge had forfeited. So different scenarios according to the JAC person. The judge has denied that request, so she would not be having a standby attorney to assist her and help her. And yeah, that was a pretty big deal.
What now we're addressing, ma'am, is September 17th,
Right.
the deadline, which is 2 weeks after having the physical view of any of the physical evidence. It sounds like Mr. J is going to try to meet with you.
That's why I thought she was going to put in a motion for a continuance. Maybe, I mean, she has 3 motions in her hands right now. Maybe one of those motions is a motion for a continuance, because the trial's going to happen in like 2 months. Oof.
Full view of any of the physical evidence. It sounds like Mr. J is going to try to meet with you pretty promptly regarding the digital evidence. So you'll have plenty of time to review that in 2 weeks at a minimum, or 2 weeks at most, rather, to lodge any objections to the physical evidence.
I understand. I just don't understand how to file objections.
I cannot answer that for you. That would be me
Yikes.
providing you legal advice, which I'm prohibited from doing. All I can tell you is that
I think the JAC said they're going to give her like a pro se, like a little handbook or something like that. I don't know, but that might be able to help her. I tried looking it up online, like, oh, you know, is there like a handbook for people who are doing pro se in criminal court? I only saw one handbook for if you're doing an appeal, and then another one was for like civil litigation. I wasn't really able to find anything for criminal, so maybe they have something internal that they can just give her. You know, I don't know. Yikes. Okay. Sorry, I want to go back just a little bit here.
or 2 weeks at most, rather, to lodge any objections to the physical evidence.
I understand. I just don't understand how to file objections.
I cannot answer that for you. That would be me providing you legal advice, which I'm prohibited from doing. All I can tell you is that if you have objections to any of the exhibits that the state may seek to move into evidence, you will have to lodge those objections by the close of business on September 17th. And those objections will have to be in writing. If we have to have a hearing on those objections, that hearing will be held on September 26th.
Okay. And if I may ask, are these being delegated, or I'm being incorporated in this in order for me to be able to say yea or nay?
I don't know what that means. What do you mean delegated?
Are you delegating to me as you delegated everything else in regards to taking my counsel and all of your orders?
You are representing yourself for the reasons that the court identified in its 16-page order. It is your responsibility, as you are representing yourself and proceeding pro se, to comply with the court's orders and deadlines. So if you have objections to any of the exhibits that the state may be seeking to offer into evidence, be it digital or physical, based on your review of those, the deadline to submit those in writing would be on September 17th.
Okay, so you're making statements, so I don't have any say in it.
I've asked you what your thoughts would be as to when. You've never provided me in a disagreement with regard to that date as of yet. You've asked questions about your motions that I haven't seen yet, your desire to have hard copies, which we addressed at the last hearing, but I'll be glad to address it again today. You have yet to tell me that that date's unacceptable for you, and if so, why?
I wouldn't necessarily say unacceptable. I'm just uncomfortable with agreeing to a date when I am pro se and have never been pro se before and do not know what I'm doing. So I just want to make sure that I do it correctly and have an understanding also, if you are proposing that I go to trial within 62 days, that I know what I'm going into and what I may expect. So I didn't know if this would just be easier on everyone else if they just delegated the date and gave me a printed copy with your order and whatever information you have. I don't know. I don't know either if you all are just proposing that because I'm incarcerated, just the dates are what you tell me. I don't know what I'm doing. I do not know what I'm doing. So I'm trying to learn as I go, which is why I'm grateful for everyone's patience. But at the same time, though, for me to accept this date and then not be able to meet it, what happens when that happens, if it should happen?
I can't answer that question. Again, that would be me providing you legal advice as to what to do if something happens. I simply cannot answer that question. I'm not allowed to.
Okay. Well, I'm with the court, so whatever it is that you all are trying to do in order to expedite this even more than what it's being expedited, I'm guessing I agree with September 17th.
Okay. Now, ma'am, I believe that takes care of all of the deadlines with regard to the state's exhibits. Now I want to address the deadlines for any exhibits or witnesses that you may be seeking. I am mindful that you will be receiving the discovery today. and that you have not had the opportunity to review some of the items that may be in the discovery. So how much time would you like to provide to the court the list of exhibits that you may be seeking to enter and the list of witnesses that you may be seeking to have testified in a defense should you choose to put one on?
Please understand that I do not have access to a normal phone. I don't have access to a normal phone at normal hours. So I am trying to overcome the hurdle of trying to, number one, locate any of my witnesses, and then also try to communicate with them on a payphone only telephone call that I do not have regular access to, and that limited to only 50.
Yeah, I was wondering how she was going to do that. Like, how was she going to do depositions? How is she going to get in communication with the witnesses? Imagine being a person, and then all of a sudden you get like this is a phone call from blah 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 jailhouse. Will you accept the call? Blah blah blah. And it's just like, nope, bye. You know what I mean? Like, how is she going to do this? It'd be so hard.
50 minutes that I have to share with 62 other.
Oh yeah, I think our phone calls only last 15 minutes. Okay, the judge, what is he going to say about this?
And that limits to only 50 minutes that I have to share with 62 other
Maybe send a letter out to the witnesses.
inmates. That is a hurdle, please, that I need for you to please take into consideration in order for me to be able to try to determine my witnesses, to determine any expert witnesses. May I ask, please, does the laptop have internet access?
I'm unaware. I'm unaware if it does.
To view any documents?
I'm unaware. I can't answer the question that I don't have an answer to. I'm unaware if it has internet access.
Whom is it that I need to speak to in order for this?
We may be to inquire of the jail representative who is appearing for the hearing this morning, and if not, the captain may be able to provide that information, but I do not know if it has internet access.
May I ask your contact names from the jail?
Give us 1 second.
Please, and if also, because of the court's error of sending my information that you're referencing to the incorrect address, could you please provide me a copy of that also?
What is it that you're asked? The protocol, ma'am? That was what was most recently sent.
I don't know. Whatever it is, the last thing that I received from you in the court was the hand delivery of the order regarding
Sure.
USD.
I have a copy that Madam Clerk's already printed out of the protocol. We will have the deputy hand deliver that to you right after.
What witnesses could she possibly call in her favor? I have no idea, says Nancy. Well, it seems like police was called to the residence multiple times. So maybe some of the responders, maybe any neighbors that has heard them arguing, fighting, maybe her own kid, which I don't know if she would do that. If her kid has ever witnessed, them two fighting, maybe, I don't know, George's like friends, family, I don't know.
What I did? Oh, I sent it to Anita. That's why. Give me a second. I'll have Madam Clerk print that out for you right now, ma'am.
Thank you.
So, understanding that as of right now, you do not have hard copies, you'll be provided digital copies, and to review all this evidence, ma'am, when in time do you feel comfortable in providing the court and the state the list of your witnesses and your exhibits that you may be seeking to introduce?
I'm going to go with to be determined because I just explained also, please, that I do not have access to a regular phone. I need to locate anyone. I need to do research. I don't know if I have internet access to anyone. I don't have a phone book. There's no way that I know how to do any of this without essentials and
Oh yeah, maybe her ex-husband.
fundamental equipment in order for me to be able to provide you with those answers. I cannot promise anything because I do not know how I would be able to do any of that at this moment. I would like please to propose your understanding of a meeting that I would like to have with the captain so I can see if I can have access to a regular phone, if I can have access to an internet. Right now I have a tablet that is used for text messaging and movies and the law library that I utilize. I don't have access to the phone, I don't have access to the internet.
You can certainly have those conversations with the jail representatives. But ma'am, we were on notice today to address those deadlines, and I cannot set a to-be-determined deadline at this time. I understand that there's been some delays with regard to the discovery. As I told you at the last hearing, we're moving as expeditiously as possible to get you that, and it took some time for that process to be created. That process is going to start today. Mr. Lane's here, representative from the Orange County Jail will be here. That handoff will take place. You'll have access to that laptop with all the information today.
If the defendant's not going to make a suggestion, maybe.
Wait, hold on.
And jail will be here. We're moving as expeditiously as possible to get you that, and it took some time for that process to be created. That process is going to start today. Mr. Lane's here. Representative from the Orange County Jail will be here. That handoff will take place. You'll have access to that laptop with all the information today.
If the defendant's not going to make a suggestion, maybe state.
Sure.
My suggestion would be to give her 14 days after the point that the specific evidence identified by the state to be used at trial is provided to her. So, for example, the physical evidence, which we plan on giving her the list of those physical items well in advance of September 3rd. That will just be the date that she can actually see them. But my suggestion for those physical evidence items would be September 17th, and then 14 or 15 days after whichever day we get the specific list of digital evidence items to her would be our suggestion.
Okay. Ma'am, are you amenable to that? That 14 days after you've had the opportunity to review the digital evidence, and 14 days after you've reviewed the physical evidence to provide your exhibit lists?
I don't feel comfortable with any of this. I don't have the same opportunities as the state or any attorneys prior. So I feel that you all are pressuring me and forcing me into these dates which I may not be able to meet or exceed.
Can I add that obviously either side, if there's good cause for why a deadline wasn't met, if something comes up, then we're not prohibited either side from complying with the rules of discovery afterwards. But there would just need to be a cause shown at that point.
Do you understand that, ma'am?
I do.
That I'm setting these dates for now, and if either party can establish good cause why these dates should be moved.
Yes, and that is why I'm trying to make everyone aware prior to all of this to understand my circumstances by being incarcerated and not having access to a phone, not having access to the internet, and not having access to many more other, like I said, basics, fundamental basics, which is why I'm making you all aware now, so you are aware that when the time comes, should it lie for good cause, I'm stating my good cause is now, if not, there are additional at that time.
Ma'am, as of right now, the court is inclined to agree with the state's suggestion that 14 days after viewing the digital evidence, which will take place no later than September 3rd, sounds like it'll take place way in advance of that, you are to provide in writing your list of exhibits that you want to attempt to move into evidence. 14 days after viewing the physical evidence on September 3rd, you are to provide in writing the list of any exhibits that may be physical that you intend to enter into evidence. Those dates can be extended for good cause that may be shown. State, would you like the opportunity to...
Wait, have you guys heard her jailhouse calls? I don't think I've heard of any of her jailhouse calls before. Oh, maybe they are out there.
...review those exhibits similar to an evidence viewing that we're having with Ms. Boone reviewing state's exhibits? Would you like a similar opportunity to review any of her exhibits?
If the defense has any physical evidence to place in evidence, I can make those arrangements with Ms. Boone.
Okay, all right. I will set a deadline for the review of September 26th.
Is the review that you're seeking out, please, for my exhibits and witness list?
That is correct.
Is it September 26th or 22nd?
I would also propose a similar date of September 17th for any of the witness lists for the defense. And Mr. J, would you be in a position by the 1st of September to provide any witness lists for the state?
She should have the witness list in the discovery that's being provided. As far as the order and the list of witnesses that we're going to call at trial, we will get in that ahead of 9/3.
Okay, all right, so the deadline for the state's production of the witness list will be September 3, no later than, and September 17th for Ms. Boone. Ma'am, similar to the objections to any discovery, that'll have to be in writing as to who it is that you may be calling as a defense witness. You'll have to provide that to the court in writing by September 17th.
Yes. And if I may ask, please, what you're typing, is that for an order or for today's proceedings?
It is for an order, which you will be given a copy of. It may not be able to be hand-delivered to you, ma'am, because I'm going to have to move some stuff around based on my scratch notes here, but at a minimum, it would be mailed to the your proper address due to that clerical error. That will not be an issue.
Wonderful, thank you.
Okay, I think that addresses all the issues with regard to production and hearings on any objections. Anything else from the state that you believe we need to address from a scheduling concept?
We're good with the scheduling concepts. Thank you, Judge.
Thank you. Ma'am, do you have any questions with regard to the scheduling concepts or deadlines that we've addressed this morning?
Other than what I have made known to the court, I do not.
Okay.
Are we going to address the 3 motions that she has in her hand?
Bruce, can you see if Mr. Sergeant Casey's here? He is
I
here.
am, Your Honor.
All right, very good. Sir, could you come on up, please? Madam Clerk's going to go ahead and swear you in. You can stay at the podium, sir. No, just the podium, Sergeant.
Oh, sorry.
If you could raise your right hand, Madam Clerk's going to go ahead and swear you in.
Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
All right, sir, good morning. Could you state your name for the record?
Sergeant Thomas Casey.
And what's your position at the Orange County Jail?
Sergeant.
And what are your duties and responsibilities, sir?
I'm over transportation, downtown court holding, BRC courts, medical security, and the juvenile assessment center.
Okay. Are you aware of the protocol that Captain DiGiovanni created with regard to Ms. Boone's use of the laptop?
I am.
Okay, all right. Have you had the opportunity to review that protocol?
I have.
Okay. Mr. Lane, can you come on up here, please, sir?
I believe she had shared custody with her ex-husband at the time.
Sir, good morning. Could you raise your right hand? Madam Clerk's going to swear you in.
Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and
I haven't seen any of the family court stuff.
All right, sir, good morning. Could you state your name for the record for me?
Willie Lane.
And what's your affiliation with Prison Break Investigations?
I'm the owner and chief investigator.
All right, sir, last time I saw you, I had tasked you with digitizing 2 banker's boxes of information, and you said that you would endeavor to accomplish that task by today, understanding that you were out of town for your son's wedding. I hope you had a great time. Were you able to fulfill that task, sir?
Yes, sir.
Okay. How many jump drives or drives do you have?
Of the digitized information, there's one of those. This drive here is a copy of all digital discovery that I have in my possession from this Boone, for the court's needs if they wish to facilitate that through the, figure it'd be easier to facilitate it now through the jail than me trying to bring it in myself.
That's exactly my thought. So you've shown to me, sir, a small thumb-sized USB jump drive. That USB jump drive is the information that was contained in the 2 bankers boxes, correct? And the other jump drive that was the larger of the 2, that jump drive is any digital information that you've had previously by virtue of being the investigator.
Yes, sir.
Okay, all right, the record's going to reflect that information is going to be hand-delivered by Mr. Lane to Sergeant Casey. So Sergeant Casey, if you could please take custody of those 2 thumb drives. And I'm going to ask you, sir, to comply with the terms of the protocol, to have those added to the laptop. It'd be available for Ms. Boone's use today once she's returned to the Orange County Jail. Do you have any questions for Mr. Casey?
No, Your Honor.
Okay, sir, thank you very much. If you could proceed with that task, I appreciate you. Thank you. Mr. Lane, you took custody with you, sir, as well. Well, before you leave, Sergeant Casey, state, do you have any questions for him?
No, Your Honor.
All right, ma'am, do you have any questions for Sergeant Casey regarding his compliance with the protocol as provided to be by the captain of the jail?
Mr. Casey, could you please make note to Captain DiGiovanni that if she has time at some point, as soon as possible, to please sit down with me for about a half an hour to go over quite a few things that I need to have resolved?
I'll look for her.
Please, in regards to the laptop.
Okay.
Thank you.
Thank you very much, sir. Mr. Lane, when we were last here, you also had 2 bankers boxes. Did you bring those back with you, sir?
Yes, sir.
Okay, could you bring those back up?
Oh my god, there's a fucking bug here.
I do see it looks like the original exhibit tags are still on the top of those. Mr. Lane, did you complete and copy everything that was in both of those boxes?
Yes, sir.
Okay, I'm going to have Madam Clerk take possession of what was pre-marked as A and B for the purposes of the June 28th hearing, and we'll hold those into evidence. Do you have any questions, Mr. J, for the investigator with regard to his task?
No, Your Honor, thank you.
All right, ma'am, do you have any questions with regard to your investigator regarding his completion of the digitization process?
And my only question is, Mr. Lane, do you know when you would be coming to meet with me at the jail?
It's going to be my intent to try to get out there at the end of the week or beginning of next week.
Thank you.
Oh, that's it? What? Is that it? What happened? Hello?
I don't feel comfortable signing your invoice. I think Ms. Boone would have to sign
Okay,
it.
that's fine.
Okay.
Is it okay if I...
Hand it to the deputy. Deputy will have her sign it, and then
We're
you can
back.
take it. Mr. Lake, is that acceptable, sir? Counselor, you're muted.
Yes, that would be acceptable, yeah, if Mr. Lane, and in light of this, maybe it might be more appropriate for the court to go up to $10,000 for the investigator, because it sounds like he's already done a lot of work, so it might make more sense instead of having to come back later.
Would that change the original, the 5,500, or just we would increasing 5,000 to 10,000?
5,000 to 10,000, I think would make sense, Your Honor, just because it sounds like that we may, based on what's already been done, and Mr. Lane may have more to say about that, but based on what he's already done, I suspect he's probably used a large chunk of that 5,000 just doing this one task.
One thing I would like to add, Your Honor.
Yes, sir.
In lieu of having to come back and file another motion, is if JAC would agree to travel expenses since I'm out of county. If not, I can get that in some type of form of a writing and get it to you or to the JAC if that's acceptable.
Mr. Lake?
We'd have no problem with the court authorizing, say, $1,000 for travel expenses as well.
All right, fine. So we'll increase it from 5,000 to 10,000 for investigative costs, and for travel-related expenses, 500 to 1,000. Mr. Lake, are you going to need an order for the court file with regard to those?
We would, Your Honor.
Okay, could you submit that?
Yes, Your Honor, we will prepare the order and submit it.
All right, very good. Just send it to Ms. Barrios, so I believe you have her contact information.
Yes, Your Honor.
All right, very good. Thank you, sir. Mr. Lake, thank you so much, sir.
Yes, sir.
All right.
Judge Keenan,
Yes, ma'am.
forgive me. What is his name, please?
That's Christian Lake. He is an attorney associated with the JAC, the Judicial Administrative Commission, regarding costs for indigent defendants.
The big screen guy.
All right, state from a scheduling perspective or the protocol, which I know I filed a notice of filing, if I'm sure you've had the opportunity to review it. Anything else we need to address from that?
We're good on scheduling, Your Honor. Thank
Okay,
you.
thank you. Ma'am, anything else we need to address regarding scheduling or the protocol other than what you've already addressed this morning?
Will my investigator be present at anything for and with me?
I can't speak to for or anything, but based on what we discussed today, your investigator will be there for the digital review, which will take place no later than September 3rd.
Okay, yes, I would like to have some type of witness from
He will be
the
there.
site also.
He will be there. Mr. J is going to be recording the conversation as he identified previously.
Thank you.
Now, ma'am, you made reference to some motions that you may have brought with you this morning.
Yes, please.
All right, if you could hand those to the deputy. Also, to the extent that the deputy has not already done so, I printed out a copy of the July 24th, 2024 protocol regarding your use of the laptop at the jail, and I'm going to ask the courtroom deputy to please hand deliver a copy of that to you. It was mailed to you, it was read to you at the last hearing, but now you have a physical copy of it, ma'am, to the extent one was not already provided to you.
Oh, yes, I
What is her defense going to be? We don't know yet.
have not received this yet.
Okay.
And then also there was another printout that she was going to provide me with, which I believe was a memorandum for today's date.
I can only go by the direction of what her previous attorneys were trying to do. It seems like they're going to go for the battered spouse defense, but I don't know if she's going to continue with that. I'm sure she is.
I haven't, she being who, the captain?
No, I'm not sure her name.
Oh, Madam Clerk, no, the only thing she's printed out for you right now, ma'am, is that protocol. I'm going to be finalizing the order, and like I said, I may be able to finish it before we're done with the hearing, and I'll hand deliver it to you. If I cannot, it'll be mailed to you.
Yes, I understand. It was regards to another document proposing the dates for today's hearing. And I guess it was some type of notice. That's what please that she was going to print out to give to me, so I have that.
Okay. Mary,
I did not receive that, nor did I receive this protocol list.
as to everything that was being discussed, can you print out a copy of it first? It should be in the court file. All right, ma'am, let me take a moment to review your motions. Give me a moment here.
Thank you.
All right, I guess we can forward through this as the judge is looking at her motions. Does the battered woman defense imply she acknowledges committing the crime but then argues it was justified? I believe it's a sort of, it's a form of self-defense. So I think so.
Ma'am, with regard to one of your motions, the motion for
But
defense.
it's kind of bizarre because, you know, again, he ended up inside a suitcase. It's not like he had gunshot wounds or stab wounds, you know, and it looked like she was trying to defend herself at that point, at that time. So I don't know how she's going to argue that. I mean, she can say that like, oh, we have a history of violence towards each other. I think he's actually even been in, if I remember correctly, I think he was in jail because the police were called for domestic violence and they did jail him. I know she got in trouble too, but I don't think she was ever, I don't think they ever took her to jail for that. But I don't know. It's just really weird because, you know, the jury's going to be like, well, he was in a suitcase. So.
Immediate address correction. As identified earlier, there was a clerical error using the general P.O. box as opposed to legal mail. That's been remedied.
No, I love Toni Collette. No, not Toni Collette.
So I'm going to go ahead and grant that motion as that's already been remedied, but I don't have a problem granting your motion for the correct address for any legal mail.
But she said that they were playing hide and go seek and she put him inside the suitcase. How is that hide and go seek? Hide and go seek means one person runs and they hide while the other person goes and seeks them. If I'm helping you go into a hiding spot, that's not hide and go seek. And it was only played by the two of them, you know, if you believe what she says. I think she made the hide and go seek bullshit up. You don't know how he fit in a suitcase? I think he's like on the shorter side. Have I seen police records? For some reason in my head, it's like, I think he's like 5'5" or 5'4", but I could be wrong. I might have seen his height somewhere on like police paperwork, maybe. Yeah, the video is so hard to watch.
Delivered motions. It is the motions for sir to review the hand-delivered motions. It is the motions for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom. The second motion is the motion for defendant to lawfully receive, review, utilize the original hard copy discovery, parentheses 2 boxes, (A, B, parentheses, submitted to the court by former attorney, parentheses S, and parentheses, on June 28, 2024, for preparation of trial in her criminal case. Just review those, Counselor, and just let me know when you're ready to address them.
Your Honor, in regards to the first motion, we need to notice the Sheriff's Office, who is in charge of courtroom security, so we're not able to address that today unless they're allowed. I don't know if you're able to contact the person that's in charge of that today. Otherwise, we would need a separate day for that motion. Okay. As far as
She zipped him in, that is not hiding. Yeah, I think maybe they were like, you know, just drinking, they're just fucking around, and then probably made some jokes about the suitcase, and then he like went in willingly, thinking that she wasn't gonna keep him in there. I was thinking maybe that, or maybe he passed out and then she put him in there and then he woke up in the middle of the night and was like, oh, like, shit, Sarah, like, help me get out of here. I don't know. Those are the two scenarios that I was thinking that could have happened.
the second motion, it's completely up to the defendant. We have no standing to say anything about it. If she wants to have her documentary discovery in hard copy form, that's between whoever and whoever, but not the state of Florida.
Okay, all right, I appreciate that, sir. Ma'am, with regard to your request for discovery, the hard copy discovery, you've advised me multiple times seeking to use a laptop. I've written correspondence from you asking for a laptop.
Okay.
That laptop is being provided. At the last hearing, you advised that you wanted hard copies. You've also advised me that you live in the female dormitory, you have limited to no privacy, and you have nowhere to store anything. You have a small drawer to keep personal effects, and that's it. There's nowhere, is my understanding, in communications with the captain, to place this information. There's nowhere to house it. There's nowhere to store it. You do not have, by your own admission, any place to place it.
Is that your understanding now? Are you asking me?
No, those are just statements that I know that are in the court file that you've made. You've written letters requesting a laptop. That's been provided to you.
I've never...
You have written letters, ma'am, specifically asking for a laptop.
Do you know what the date of that is?
Without me going through all the correspondence. But when we have our hearing on the issue of the your motion for freedom of movement, well, I'll notice the sheriff, and we'll try to set that up for this week so that it can be done expeditiously.
Okay.
We can address that at that time. But the jail has advised me...
Oh, was he 5'9"? Was he 5'9"?
Have no place to store this information, these hard copies. You've advised me you have no privacy and nowhere to place them. So I'm not saying no, but I don't know how I can facilitate this for you. When you do not have a place to store it, the jail does not have a place to store it.
We have an entire property department for all of the inmates on the entire compound. I've been given permission also by Sergeant.
Who?
Corporal Ward, Sergeant Dunn.
No, I have his arrest affidavit here. His arrest affidavit says he's 5'4" at the time, weighing 120 pounds. It could be wrong, maybe.
Sergeant Jesus, have the understanding that I have been forced to represent myself as pro se and have temporarily given me a property bag where I can store additional case documents at my bunk. Help me understand, please, for future reference, so I know how to approach. By my statements that I have made to you, questions were not asked in order for you to come to the conclusion that you are coming to that I did not want my hard copy. I was never formally asked by you to see if I wanted my hard copy discovery. I would believe it was the court's understanding, the judge's understanding, that it should automatically be allowed to give to me. My understanding and trying to explain to you also, so you have an understanding, is my limited...
I'm sorry, I was distracted. My dog has the zoomies right now. Sorry, there was a... Oh, I was going to read something. I could fit in the dryer, don't ask. Sepsis, is that you? To be fair, they're both very skinny. Alcohol addiction. I don't know if I heard anything about their alcohol addiction.
Restricted access to the laptop is from 8 to 4. I, with 62 days left, in order to defend
Oh, someone has the autopsy report. I haven't seen that yet, I don't think.
myself in understanding hard copy discovery. I would believe it was the court's understanding, the judge's understanding, that it should automatically be allowed to give to me. My understanding, and trying to explain to you also, so you have an understanding, is my limited restricted access to the laptop is from 8 to 4. I, with 62 days left, in order to defend myself in preparation for trial, would like to close that laptop at 4 p.m. and then pick up the discovery hard copy in the 2 boxes that I have. I haven't spoken to the captain yet. I just now received the protocol for the laptop. I know that you had mentioned it to me the last time we met with one another. So I'm confused how everyone is confused by me coming to the court with solutions and ideas and suggestions, but are being misinterpreted and misconstrued, like my letters from my attorneys, and you're coming to the wrong conclusion.
I'm not coming to any conclusion. The process was created, and I'm just reciting what you've said to me at prior hearings, ma'am. That's all I'm doing. You've told me you have limited space. You've told me that you have no privacy, and that you have a small drawer for personal effects. This is the first time I've heard anything about you having a locker or some kind of bag, or property bag, that you now have access to. That wasn't addressed at our last hearing. This is the first time I'm hearing about it. So I'm not drawing any improper conclusions, as I identified for you with the process. The jail created this process. It was something that they put together. And as I told you, we worked diligently to move forward to get with the jail to have this done. There's no nefariousness here. There's no undermining. There's nothing along those lines. I want you to have this information. And as I addressed at the last hearing, I could not copy it. I can't look at it. I can't look at what's in those 2 bankers' boxes. Ms. Barrios cannot. No one associated with my office can look at it. We had to use your investigator to do that. And what the jail has advised me is that they were not in a position to take both those bankers' boxes because of space and potential hazards. Now, if something has changed and the captain advises me that you can have those documents, I don't have a problem with you having them. But what I've been advised, as identified in that protocol, is to how and when you can have access to the information, and unfortunately it wasn't in physical form, it was in digital form. And that was the process that the jail created. They are aware it's 2 bankers' boxes. They're aware of what the information is. Everything has been out in the open to address your concerns and how to facilitate getting this information to you. No one's withholding anything. No one's trying to hide the ball.
My opinion differs.
Of course it does, Sarah. She did a little pause and like a little head thing right there.
I was never asked anything. Just like my letters to you prior to you forfeiting my right to counsel, I was never asked anything in order for you to have a better understanding.
Ma'am, I'm not going to revisit that.
I am not, you never asked me in regards to the hard copy.
Hang on. Yes.
How quickly can we have an evidentiary hearing with the captain or whomever we need?
My understanding is she's on vacation this week.
Okay.
So, which is why Sergeant Casey was here, because Captain DiGiovanni is on vacation. And I cannot recall off the top of my head when she's set to return. She's set to return on the 12th.
So, if the document, what would be the process? Because it's marked, tagged, and in evidence, so there would need to be a motion to get it released from evidence.
I mean, I would entertain an or a tennis motion to have it released from evidence. The concern, as, and Mr. J, this is the first time I had the opportunity to discuss this case with you. I know I've been dealing with Mr. Cacciatore. We had a hearing, and I'm sure you're versed on this, but let me just kind of bring you up to speed. We had a hearing in June, and at that point in time, I forfeited Ms. Boone's right to an attorney based on her conduct and alternatively a waiver, and I'm sure you've read it. Thereafter, the court endeavored to figure out how to get those 2 bankers' boxes that Ms. Cashman had provided to the court at that hearing in Ms. Boone's possession. It took time for the jail to come up with a policy and a procedure for that to happen. I was advised by the captain that they could not take custody or possession of those 2 bankers' boxes because of...
I have this slightly sped up, by the way, so he might sound a little bit impatient, but I think he sounds more patient than what he really sounds like. It's just like sort of sped up.
A, storage, and B, because of the hazard. Now, if the jail's in a position to revise that by virtue of Ms. Boone identifying a property bag or something that may be available for her use, I am 100% on board. If the jail says, yeah, we can facilitate and make that happen, her getting that information. I'm just traveling with what I've been provided, and the protocol that was provided to me that's been filed in the court file was not inclusive of providing her hard copies.
I understand. I'm just trying to find a solution. So
Same.
If she moves or attends to release those 2 exhibits to her investigator, then perhaps he can try and get them released to her. And if he cannot, then it sounds like on the 12th we can revisit this when the captain's back.
I think I don't know if she returns on the 12th or that's when her vacation ends. It's a Monday, so I'm assuming she'll be back, but I don't want to make any affirmative statements on that. I don't have a problem. Mr. Lane's had this discovery. I don't have a problem with him taking custody of it again. And if he's able to deliver it to the jail and they allow it to be released to Ms. Boone, I don't have a problem with that. I have no problem with it. I'm just traveling on what the jail has advised the court in the creation of this process.
So if she wants to ore tennis, which means oral motion, move to release those two exhibits, the state has no objection, and it sounds like if Mr. Lane can't get them to her, we'll be able to revisit this in the near time future.
Yes.
Just so that she's advised. So I don't want to ask her, but perhaps the court can ask her.
Sure. Ma'am, the state has recommended a position for, in an attempt to get you these hard copies. Is that something that you would like the court to, would you like to follow with the state's suggestion and ask of that of the court orally this morning?
I'm not understanding what it is that he's trying to do. May I please propose that the hard copies go to Mr. Lane, and then once I have permission by the captain and new member, he can release them to me?
Granted.
No objection to her motion.
Okay. Mr. Lane, thank you for staying, sir. I appreciate you. If you could come back up here, sir, and take custody of both of those banker's boxes. I will have Ms. Barrios coordinate a hearing for the 13th at 8:45. Why not? We cannot do the 13th because it's pre-trial. You're correct. We will have a hearing on August 14th, if necessary, on Wednesday, August 14th at 1:30, if we need to address the jail's position in taking hard copies if Mr. Lane's unable to have it delivered. And Mr. Lane, you had advised earlier when Ms. Boone had inquired of you as to when you might be able to go visit her. You said the end of this week or by next week. If when you go to visit her by the end of this week or next week, bring that with you and see if the jail would be in a position to take it. If they are, I'm going to ask you to file a similar notice, sir, that that information was provided to the jail on what date and to whom. Okay? All right, thank you.
Your Honor?
Yes, ma'am.
What would the hearing be for on the 14th then, for the jail taking?
The hearing on the 14th, ma'am, would be if Mr. Lane is unable to have the jail take physical custody of those two boxes for your review outside of the laptop,
Yes.
we would have a hearing to address what, if any, protocols the jail may be able to utilize in you having those documents. It may not be necessary. We're going to go ahead and set it if we need it. If we don't need it, we will not have a hearing.
God, we have so many dates.
So there would not be needing to be made an updated evidence control sheet right now. It has been passed to Mr. Lane.
As of right now, the court minutes are going to reflect that what was pre-marked as A and B from the June 28th hearing is being provided to Mr. Lane.
Thank you.
Okay. With regard to your reasonable freedom motion, I'm going to set that for this Friday. Is the state available at 8:45 on Friday?
No, I looked at it, please.
That is the 9th, ma'am.
We're available, Your Honor.
Okay. Ms. Barrios will coordinate with a representative from the Orange County Jail to address the reasonable freedom motion. Ma'am, I'm going to hand file both of these motions with Madam Clerk, okay?
Thank you.
All right. Is there anything else we need to address this morning, State?
Not from the state.
Anything else we need to address, Mr. Motion?
We're available, Your Honor.
Okay. Ms. Barrios will coordinate with a representative from the Orange County Jail to address the reasonable freedom motion.
Reasonable freedom motion. Okay, I wanted to reasonable freedom motion. Okay.
Ma'am, I'm going to hand file both of these motions with Madam Clerk, okay?
Thank you.
All right. Is there anything else we need to address this morning, State?
Not from the state.
Anything else we need to address, Ms. Boone?
Please bear with me, just please, 1 moment.
Uh-huh.
What was the conclusion for the sensitive issues of having the media incorporated in the courtroom?
I need to research that matter a little bit further
He already said that twice already, babe.
before I can make an order that would prohibit media access.
Wait, is the reasonable freedom motion, is that separate from her wanting to be able to like free roam around like with no handcuffs and stuff right now when she's like in the courtroom? Or is this a separate one?
Do you know what your deadline may be or estimated?
It'll be well before the 3rd. That's deadline is set for September 3rd at 9.
Yeah, I don't know. So for some reason, the audio is like weird, but when people refresh, they said it was fine. Try refreshing it, see if that works. That's what everyone else did earlier. I don't know if it's like a YouTube issue.
9 a.m. when we'll have that viewing. I will endeavor to get that done as quickly as possible. Ma'am, you also had asked for a list of the persons that Captain DiGiovanni had provided. The names of the persons at the jail regarding the laptop protocol is Captain Giovanni, Donald Casey, who was here this morning, Stephanie DeJesus, Sonia Robinson, Courtney Battle, and Malik Muhammad.
Thank you for that. Would you be able to provide provide me with a hard copy?
I will put that in the order that'll be mailed to you, ma'am.
Wonderful, thank you.
Okay.
If I may, I don't know if I'm allowed
Right, I think he granted that, right? So I think this is something else. Okay.
to address the state directly.
Yeah, you represent yourself, absolutely.
How do I go about getting a copy of my phone or utilizing my phone? Is that something that can be brought to the courtroom and during the evidentiary, the physical evidence, that I might be able to utilize that?
So my understanding is there was an imaging done of your phone with software called CellWrite, and that is part of the digital discovery that has been provided to you. If you are talking about the physical device being re-examined by your own expert, then you would need to find and retain your own expert to do that without giving you legal advice or suggesting that he is the person who hired. I know that defense attorneys in this area hire somebody named Richard Connor, C-O-N-N-O-R, and then that will be between you and the JAC and him, whether or not he wishes to work for you and at what rate, and so on and so forth. And then that examination would be done by him with us being present if we want to be present.
That's like a pretty helpful answer from the state.
Yes, I have reviewed, I believe, 2 or 3 different thumb drives were given to me at one point, where I researched all of them extensively, also included with Mr. Lane, and it is nothing of use. It's primarily cookies and history and so forth. So that's why I don't understand who it is, a legal expert that can give me a mere download of my entire phone in regards to videos and pictures and contacts. I could probably supply a witness list sooner than later if I were to have accessibility to my phone in regards to my contacts. That's why I didn't know if it would be allowed to have my phone physically here in the presence of everyone, including law enforcement, to be able to physically look at my phone and go through it and to see what I can extract myself while here in the courtroom before trying to figure out how to locate and contact an expert to download all of that to receive.
So all of that information should have been downloaded, and I'm not sure what has been provided to you, but we will be double checking that.
If it's not been provided.
Yeah, your contact information, all the videos and photographs, everything on your phone should have been downloaded. And what you may have reviewed is just a PDF file called the timeline. But there is additional data there, and we will make sure you have that. And then when it comes time to our digital evidence deadline, which I hope to exceed well before 9/3, we will be identifying which portions of it is of your phone, if any, that we seek to introduce at trial. So it may be texts from December 2nd, 2019, whatever it is. We will identify those.
Well, I wouldn't expect her phone to be in service.
We will
I'm sure that's already been canceled.
Because obviously your entire phone, however many gigabytes it is not going to just come into evidence. Because like you said, there's so much of it would be not relevant.
Yes,
Hi,
thank
Kiki.
you. So you all have already had access to my phone and have researched it fully?
We're not going to talk about our work product. I'm telling you what, based on my experience from other phone examinations is, all that information should be there. And it's typically presented in 2 different fashions. One is a large PDF, typically hundreds of thousands of pages, depending on how much you use your phone every day. And then there's a separate big digital image file that is read with what's called a UFED reader. And then that is where you can go in and look at everything.
Yes, sir, thank you. I've not seen any of that.
We were going to make sure that that is taken care of.
And that, just as clarification from the court perspective, is that something that would have been provided in discovery to prior counsels?
Yes.
Okay, then, ma'am, as Ms. Cashman identified, she had everything. It's already been digitized for you, and to the extent you're able to have the hard copies, it'll be provided to you. So you'll have access
Should be part of the discovery, right?
to all that information today when you return to the jail.
Yes, thank you. None of it was gone over in any way, shape, or form with Ms. Cashman or any prior. So this would be a milestone, a big milestone for me to be able to finally do that. So now, if I don't have what I need or I'm looking for, how do I go about? I know you all can't tell me because of legal matters, but do I need to write a motion? I don't know what I need to do in order to finally get a copy mirror download of my phone. If it could be brought to you for physical, with the other physical.
So again, that is going to be something that requires an expert. And then if we get a defense expert and the JAC pays for it, then we make arrangements to meet with that expert. That expert will have the opportunity to image your entire phone just as we did, and you all can work with that image. And you're going to be, if you don't already, on those thumb drives that Mr. Lane has, if you don't already have the full extraction and not just the PDF timeline of your phone, you're going to make sure that that is provided.
Okay. So that is not able to be included in the other physical evidence that you all are supplying?
No, what I'm saying is there's 2 different ways that I see phone extractions. One is the PDF, which is what I think you're referring to, is the timeline of this communication, so on and so forth. And then there is the actual ginormous file that is read with a UFED program, and all that should be provided to you. Hopefully your laptop can use it. It does take some specifications on the computer to open it. In fact, we're addressing those issues at our office with our own computers, and if it doesn't work, we will cross
This is what trial's going to look like. This is what the sidebars are going to be like.
those bridges as we get there, and I've worked with Mr. Lane before. Just let him know. Mr. Lane knows how to find me. We will work this all out and get what you need.
Absolutely, yes. I am grateful for your information. Just to clarify, please, during the physical evidence of me viewing that here in the courtroom, am I not able to physically open my phone and search through it?
No, because
Okay.
it needs to be in a Faraday box where radio signals don't come and go, because anytime you turn on your phone, it changes the contents of the phone.
Thank you
You're
very
welcome.
much.
Ma'am, do you have any other questions?
One moment, please. Okay, so everyone is aware that I'm in the process of trying to talk to the captain. And handcuffs. Okay. Your Honor,
Yes, ma'am.
I believe I am okay for right now. You and I do not have a direct way of communication, and I didn't know. Another big hurdle is if the laptop has internet access, where I don't know if emailing or messaging or whatever, however it is that you and I can communicate, rather than snail mail, I mean writing you a letter. I don't know when I write a letter how soon you receive it, because sometimes it's days or weeks that it is uploaded to the clerk's website. Do you have a general time frame of when you actually know something? Because you already have my address correction, but I don't believe I've updated.
It's been updated
No,
now.
I mean on the clerk's website.
I can't speak to what's on the clerk's website. I know for the purposes of my records and getting information to you, that clerical error has been remedied.
Do you have any other suggestions? If I do not have internet, would my only possibility to correspond with you be via mail?
That's my understanding. And you asked when I receive things. I get it as soon as I get it from in the mailbox. So we check the mailbox every day. As soon as I get it, it doesn't go to the clerk, it goes directly to me. And I review it. As you saw with the motions that you made reference to at our last hearing, that you had 5 of them, we set those for hearing immediately. And I intend on continuing to try to do that to facilitate prompt resolution to any concerns or issues or motions that you may have.
Thank you. And if I do have internet access or I'm able to put on, if it's not already, am I able to correspond with you via email?
You cannot correspond with me directly, but you can have conversations with my judicial assistant to the extent that you do have access to internet. I'll make sure to include her email address and telephone number in the order setting the deadlines that we addressed this morning.
Yes, thank you. And for any, I'm not sure specifically which JA, but as soon as something is scheduled, could you all please make sure that I'm included in the certificate of service or portal or whatever it is I might be attached to in order to receive notices to be properly prepared?
Notices have been sent now. To the extent that there was a clerical issue, that's been remedied, but you have been copied on everything that's been filed with the court, including the JAC's response, the notice of the hearing that was set for today, and the notice of the filing of the protocol. With that, I will see you all this coming Friday at 8:45 to address the motion regarding reasonable freedom in movement. State anything.
See you guys again. So I think this week is going to be pretty busy. So we're going to have another Sarah Boone hearing this Friday. There's going to be a Karen Reed hearing on Friday as well. And then, is there another one? I feel like there's something else here. Sarah Boone, Karen Reed. No, just those two? Okay. And then I wanted to cover Alexa Treviso stuff maybe tomorrow.
Anything else?
No, Your Honor.
All right. We'll see you all Friday. Thank you very much.
Thank you very much.
We'll return Ms. Boone to the custody of the Orange County Jail.
Whew, that was a long
Yes, ma'am. Thank
one.
you.
That was a long one. Oh my God. How long was that? That was almost 2 hours long. Jesus, that was a long one. Oh gosh. So should we just... Okay, we're going to work backwards here. So I'm going to go over the dates. What's going to happen in Sarah Boone trial going forward between Sarah Boone, the state, the jailhouse, private investigator, and then we'll go backwards and we'll read parts of the motions that she filed, the JAC response, because I haven't done that yet. We'll do it today. Oh gosh. Okay, so let me take a look at what we got for the scheduling. Oh, a lot of stuff kept getting moved around. You know, honestly, I think that could have happened had she had like representation. I think that hearing could have been like way less than 30 minutes. But because, you know, she's new to this, she doesn't know what she's doing. She doesn't have attorney experience. I a lot of it is just her asking the same questions over and over again. I'm okay with her getting clarifications. I think that's okay. You know, you want to get clarifications, but when the judge has repeated something like 4 times already and he's made it very clear, at that point, it's just kind of like, oh gosh, okay, what are we doing here? What's going on? Okay, so August 9th, this Friday. Okay, they're going to discuss the reasonable freedom motion. I don't know what that is. I have no idea. Maybe it's her wanting, because I remember before she was talking to Patricia Cashman, and she wanted to be out on bond. She said the attorney lied about something. We don't really know what happened. So I don't know if that has something to do with that or if that's something completely different. I tried Googling reasonable freedom motion and I'm not really getting anything. So I don't know if that's a motion she just like titled herself, or maybe that is a real motion that it's just not coming up. Wait, let me type in Florida. Yeah, I don't know. I'm not really getting anything with the reasonable freedom motion. But if you guys have an inkling of what it might be, let me know. So see you guys again this Friday for that. And then September 3rd is when the state is going to have a deadline for their witness list. But I think they're going to try to meet with Sarah Boone prior. That way they can go over, they can have like the conversations be recorded. They did mention it's not going to be admissible to use against her. They'll talk about if there's any plea offers, maybe. They mentioned other matters. They're going to go over the list of digital evidence. And then they're basically going to view all that together with, we have a Mr. J, which I think is from the jailhouse, Mr. Lane, which I think is the PI, and then Sarah Boone. And then the state will be there. September 3rd, they're going to have an in-court hearing to lodge objections. That's where they're going to have the evidentiary hearing with the judge. And Sarah Boone did express her concerns about whether or not the media is going to be present. She obviously doesn't want the media to be present. The judge says he's going to research that and he'll try to figure out what to do with that. Sarah Boone's going to get all of her discovery today by USB. They're going to figure out whether or not they can give her the boxes so she can have the hard copies, because again, she gets to view the evidence on her little laptop from 8 to 4. She wants to be able to view it, I don't know, 24/7, whatever time she has. That way she can better prepare for the trial, but they don't know if she can have the boxes, because previously they did have someone from the jailhouse. I think it was a captain who said that, we don't have anywhere to store this. So no, just give her the digital stuff. That's for September. What else do we have? September 14 will be a hearing. Now, this is just something they just put on the schedule for now. They don't know if the hearing's actually going to happen. But if there is an issue with her having those physical copies of those 2 boxes, then they're going to do a hearing to figure out what they can do about that. So this hearing may or may not happen. September 17th, they're going to set a deadline to the state's exhibit. The defense is going to provide a witness list. So we'll see, who Sarah Boone is going to call to maybe testify if it's not already on the state's list. September 26th, they're going to have case management, and then also Sarah Boone will receive discovery, list of exhibits and witnesses on this date. And then I think she also gets a response time, right? I know they were going back and forth with the response time because she was like, oh, I don't have time to respond, blah, blah, blah. All right, well, that's, we have a lot of dates on there. Bring on the box fort. No box fort. I think watching Sarah Boone will be less crazy than watching DB do their thing. Yeah. With DB, I don't know. I just saw snippets of it and it was just very hard to watch. Okay, all right. It'll be very hard for her to explain the video. I think she's just going to say, well, I was really drunk and I didn't know what I was doing. Hence, I forgot about that video, didn't delete it, and law enforcement got a hold of my phone and they were able to view it. I think she's going to say something like that. Oh, I was so drunk, I didn't know, which is not a excusable defense. So, let's go to Sarah's, oh gosh, let's go to the court minutes, actually. All right, so court minutes. Oh, I could have just read this. Court minutes from today. The court addressed several of the defendant's motion and set deadlines as it relates to exhibits and witness lists. The court will prepare a specific order of all the deadline dates, as what was stated for the record, including the cause for JACs. The court provided the defendant open court a copy of the email dated 7/24/2024 from Gina Giovanni, that's the captain of the jailhouse, and a copy of today's order setting hearing. I should wear my glasses, actually. Court witnesses sworn and testified: Christian Lake with JACS investigator, Billy Lane, representative from Prison Break Investigation, Donald Casey. So these are the people that we saw in court today. More court minutes. The court advised investigator Billy Lane, representative from Prison Break Investigations, to release the thumb drive to Sergeant Casey, who we saw going up there and getting sworn. represented from the Orange County Jail in open court. Investigator Billy Lane also released 2 boxes of discovery back to the clerk in open court. Defendant requested that the 2 boxes of discovery released back to Billy Lane. The court granted that. The clerk released a 2 boxes of discovery back to Investigator Billy Lane in open court. Trial remains as previously said. Yeah, so the trial date has not been changed. That's why I was wondering if she was going to put in a motion for a continuance, but she handed the judge 3 additional motions, and yeah, none of them was a motion for a continuance. So maybe we're going to have the October 7th hearing after all. The judge changed the trial length. Instead of 2 weeks, he set it for 3 weeks now, and I wonder if it's because she's going pro se, because she's going to represent herself, that everything's just going to take a lot longer. I don't know. That's what I'm wondering. But going back on her previous motions that she filed, because I haven't read them yet, we're not going to go through all the pages, but I just want to read the parts that, oh gosh, because like I said, with the Sarah Boone letters, motions, she does a lot of like definitions. She literally will copy definitions from like the dictionary. So we're not going to read all of that, but let's just read some of it. So this is her when she requested a motion requesting immediate relief to the defendant by appointing effective standby counsel, aid, and support in preparation of the criminal case for a trial. And again, this was denied by the judge. Comes now as Sarah Boone, pro se indigent defendant, respectfully requests from the court immediate relief by providing effective standby counsel with all legal services allowed and included to assist and the aid of the defendant as a whole in the complex, vital procedural preparation with professional guidance during her forfeited right to counsel by the court as pro se attorney and in her proposed lawful representation of self in her criminal case. I mean, there was like some arguments that she made in court today, but I still want to go over this anyways. The defendants, in parentheses, justifiable reasons for requested relief and assistance are as follows. 1. The defendant's 6th constitutional right to counsel is being violated, unlawfully withheld, and forcibly removed from the indigent defendant under false pretenses, speculation, libel, and misconstruction. So again, she's trying to say that the previous attorneys all lied about her, the judge believed it, and it was all lies, you know? So just a quick little refresher on the 6th Amendment. What a nice refresher we can get. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial, okay, by an impartial jury of the state and district wherein the crime shall have been committed, okay, which district shall be previously ascertained by the law and to be informed of the nature and the cause of the accusation, all right, to be confronted with the witnesses against him, okay, to have compulsory process for obtaining witnesses in his favor, and to have and I think this is the part that Sarah thinks pertains to her, have the assistance of counsel for his defense. But again, this scenario is different because the judge has deemed that she forfeited her right to have counsel based on her previous actions. So it doesn't really, I don't think she's really using it correctly here. By the defendant's lawful practice, so we're back to the Sarah Boone motion, by the defendant's lawful practice of her entitled first constitutional right to free speech, so let's talk about free speech here, and her God-given right to do so by writing her experience, derived truth, and providing red flag exposure in her correspondence to the court requesting needed intervention to avoid present circumstances, she has completely lost her ability and advantage to properly, rightfully, successfully prepare her defense of innocence, progressively advance fairly and unrestricted, while having the ability to be leveled equally with the prosecution. So she's saying that she had a right of free speech to say what she needed to say about her previous attorneys. And she's like, well, you know, I have free speech. I can say whatever I want. I shouldn't have lost my right to counsel. Number 2, the defendant is not an officer of this court or any court or legal system as a whole. Hello, Ms. Mendez. How are you doing today? I hope you're doing well. Has there ever been a pro se defendant ever won? Someone did mention in a couple streams ago that there was someone that went pro se, but I think their case, I don't know if they won. Maybe they won. No, maybe they lost, but then their case got overturned because something happened. I don't know. They mentioned that in my chat, and I never really looked it up. But if you guys in the chat know what I'm talking about, maybe you guys... It happened recently, like very, very recently. I forgot their name. May have happened in Florida, too. The defendant is not an officer of this court or any court or legal system as a whole. She is not bound lawfully under oath or certified in any professional means to be or act as a legal agent or representative, lacking a requisite professional competency. So I'm glad that she's being true to herself. lacking experience, expertise in the field of law, presently and historically. Yep. The defendant is defective and ineffective counsel to self as a result, which therefore will detrimentally impact and impede favorable justice to the defendant. So she does recognize this. And the opportunity of the fair trial based on equality with the unprejudiced conclusion of her case. Number 3, the defendant is presently incarcerated, which is causing an ill will. Haven't heard anything. I'm trying to remember what it was. They told me the name too. It was someone that went pro se, and then, or were we talking about something that was similar to the Baldwin stuff? Maybe there was like prosecutorial misconduct. No, I could have sworn they went pro se, and then like later on, they either won or they either didn't lose and then had their case overturned. Fuck, I don't remember. I might have to go back to that stream. The defendant is presently incarcerated, which is causing and will cause unfair burdens, limitations, deprivations, inaccessibilities, and unequal opportunities in and to her ability to complete tasks and timely responsibilities. Yeah. Suitable to the vital defense of her defendant's life and livelihood futuristically. Yep. You are very limited when you're an inmate. Now, I wonder, because remember, she was assigned to a different judge previously. And with that judge, she went through about 3 other. So Padilla is the private attorney. I believe he was the one that withdrew after 2 years. And then we had a bunch of people that were assigned, but then they couldn't work on the case because there was like conflict and some other issues. And then there was Frank Bankowitz, Hobson, and then went to Patricia Cashman, right? So I wonder, since she's like, oh, this is a new judge that's overseeing this, maybe he'll give me a couple more chances and provide me with a couple more public defenders before he, really axes my right to have someone represent me. Because maybe she really thought that she was going to have a couple more chances with the judge. But I do remember, I believe it was this judge and maybe even the previous judge as well, that was like, hey, if you're not going to be able to work out with your counsel, then you're going to have to represent yourself. I'm pretty sure he said it, and I'm pretty sure the other judge said it as well. By the court rejecting professional, educated experience and the assistance of effective standby counsel to and for the defendant in preparation for production of her rightful defense, results may be adverse from the unfair, disadvantaged, oppressed circumstances to properly thrive in her forced position by the court, a pro se attorney, and the representation of self. Examples of said unfair burdens, limitations, deprivations, inaccessibilities, and unequal opportunities include. So A, defendant has not received the court to date of this motion any of her promised discovery of case or case-related materials submitted by the former attorney to the court during the unannounced hearing on 6/28/24. So these motions were actually written before the 2 previous hearings. So before today's hearing and the hearing that we had, was it like over a week ago? And remember, in two hearings ago, sorry, this is really hard and kind of difficult to talk about, but it's like hard to, okay, so we had a hearing today, and then we had a hearing about a week or so ago, okay? So 2 hearings ago. At that point, that's when the judge decided to address how she was going to get her discovery material. So, and remember at that hearing, she was like, oh, I have these motions that were sent to you. There's 5 motions. Did you get it yet? So these were written before. Does that make sense? I hope it makes sense. With only 4 days to submit my demands and motions delegated by the court on before 7/22/24. So again, that was the date that the judge said you have to submit your pretrial motions by. B, the defendant has not reviewed from the court to date this motion of any of her promised discovery or case-related materials submitted by the former attorneys to the court during the unannounced hearing on 7/28/24. Oh, did I already read this? I'm sorry. Or did she just write this again? With only 4 days to submit my demands and motions delegated to the court on or before 7/22/24. The defendant does not have access to a computer. They were working on that. D, the defendant does not have access to the internet. Not sure about that. E, the defendant has extremely limited, irregular access to the basic tablets supplied by, is that QCCD? F, defendant has access to payphones for each collected calls only, limited to 50 minutes each call. Yeah, so I don't know how she's going to be able to do the depositions, and then, how she's going to figure out the witnesses and the witness list. I don't know. I don't know what they're going to do with that. G, the defendant does not have access to organizational supplies or production equipment, copier, printer, etc. H, defendant does not have access to meeting place for privacy in case review. Preparation. I think they did give her a little room for her to be able to view her laptop on, if I remember correctly from the previous hearing. I, additionally, daily obstructions and underdetermined hardships, disadvantages. Difficulties will likely come about due to being incarcerated and once my case materials are finally received. Continued application and reasoning and further lawful support of defendant requests for immediate relief with standby counsel to aid and assist in preparation of her criminal case. I don't know if I want to read this because it's her just basically citing the Sixth Amendment. This is her dictionary definition of the right to counsel, what the definition of waiver to counsel is, which she said that she has never waived her right to counsel and that it was completely forced upon her. She actually cites a case here, but I don't know if it pertains to her. Let me see. Was there anything else I was going to read? What page are we on? Page 7. Go to page 7. Page 7. Because I think a lot of these are like definitions and stuff like that. So again, she said that she never waived her right to counsel. Now she talks about ineffective assistance of counsel. Again, she's saying that the previous attorneys that assisted her, they were all ineffective. Sorry, I'm just going through my notes really quick to make sure. I think I want to just skip to page 26. Yes. Page 26. Actually, hold on. There was something that I think she cited something that I looked up really quick. It was Smith, Arizona. See if I could find it. Did I see Arizona around here? Sixth Amendment, right to counsel, waive of counsel. People, nope. Ineffective counsel. Oh, it was this right here. Due to ineffective assistance of counsel, the federal courts in 1999 set this second sentencing aside. Smith v. Arizona. So this is one that I just like looked up really quick. I was like, oh, I wonder if it pertains to her. But I looked up this case and it seems like it doesn't pertain to her. I don't think. Joe Clarence Smith, petitioner in this case, was first sentenced to death 30 years ago. Due to constitutional error, the Arizona courts in 1979 set this first sentencing aside. Smith was again sentenced to death later that year. Due to ineffective assistance of counsel, the federal courts in 1999 set this second sentencing aside. Smith was again sentenced to death in 2004. He now argues that the federal constitution prohibition against cruel and unusual punishment forbids his execution more than 30 years after he was initially convicted. So I don't think this applies to her because, one, she hasn't had her trial yet. Where, you know, she had ineffective counsel. 2, she hasn't been sentenced yet. And 3, this is for a death sentence. And I don't know. I feel like it doesn't apply to her in any way. So let's jump to 26. I don't know. I will, because I'm not very well versed in a lot of this like stuff. So I have to look it up. I just wonder if there's just a lot of fluff written in her motions to make it seem like it has substance, and then maybe she's just trying to see what sticks with the judge. It seems like that might be the case, possibly. Especially if you don't know what you're doing. Okay, so I wanted to read this part. Page 26. What did Ms. Boone write? Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests to the Honorable Court to provide immediate relief to defendant by appointing effective standby counsel to aid and support in preparation of her criminal case for trial. The defendant is requesting collaboration, correct understanding, and overall perspective of and in her extraordinary circumstances by rendering her cognitive incapacities, procedural inabilities, and extremely limited capabilities altogether as fact, and concluding a remedy of assistance is rightfully needed to be provided to the defendant by the court. Appointment of vital standby counsel will lessen greatly her probabilities of further loss, damage, spoliation, oppression in her criminal case. Fair and equal position by fair and equal opportunity will also be greatly enhanced. Defendant's requests are in good faith and her merits are worthy in striving to successfully, lawfully, and properly perform, act, thrive, overcome her force by the court position of pro se attorney and her representation of self. So that was one motion. And again, we went over these already. These are the motions that, you know, it's like motions for proposed cause for, I think it was like to get an investigator, which they already had done that. They gave her about 10 grand of, or they gave the investigator about a $10,000 like budget for him to do his PI stuff, for her to acquire expert witnesses. But the judge was like, you're going to have to re-rate these motions later because you're not telling me what witnesses, you know, what expert witnesses you're requesting, how many hours, blah, blah, blah. Like we need information before we actually approve your motion. So she's going to have to rewrite some of these motions. So the one with the expert witnesses, the ones with, I think, let's see, proposed cause to acquire all witnesses. So expert witnesses, regular witnesses. I think there was one for depositions as well. This deposition, what is this one? Yeah, depositions. So she's going to have to rewrite some of these motions with more details. And of course, she's going to have all of her discovery today, and hopefully she'll be able to. Now, she put in 3 motions already, so I think maybe they'll be uploaded maybe in about like a day or 2 or 3 days. Usually that's how long it takes before we see like stuff uploaded. Maybe like 3 days. Let's say 3 days. So again, the judge did deny. I wish I could just go to that part where like he denied it, but the judge did deny her request to have a standby counsel. He said that she doesn't have a right to have a standby counsel, and she already forfeited her right to have counsel in general because of her actions previously. So that's a huge that was a big loss for Sarah Boone today. Oh boy, was there anything else that I wanted to cover? Erin, they let her fuck around for 4 years before she found out they were more than lenient. She doesn't deserve a plea deal. I understand why the state wants her to just go away. Yeah, we don't know if there's gonna be a plea deal on the table for Sarah Boone or not, but they did mention that if they are going to discuss plea deals or other stuff, it would happen in that meeting with her. It's gonna be recorded. She's like constantly moving the goalpost. See, she said effective standby counsel. Good thing judge denied it. She would blame the lawyer for ineffective assistance when she loses. Yeah, I mean, I'm sure, you know, if she does lose the trial, oh man. So if she does lose the trial, does that mean that for appeals, would she also have forfeited her right for someone to assist her with appeals? Or is appeals like a whole different ball game? Would she be able to get like, you know, an attorney to help her with that? I guess we'll wait and see if that happens. Was there anything else you want to cover with Sarah Boone? Let's see. We talked about JAC. JAC replied. They were in court today. They appeared, and they're the ones that actually have their webpage here. I don't know why. Their JAC webpage looks very interesting. But this is JAC, by the way. The Justice Administrative Commission. So that was the guy that was on the screen. The JAC provides compliance financial review of billings for services provided by private court-appointed attorneys representing indigent persons and associated due process vendors. They are charged with... There's another... Where is it? Service provider primarily in the areas of accounting, budget, financial services, and human resources. So that's the JAC. So basically, they're the ones that will approve the funding and all that stuff, all the budgets for Sarah Boone, her taking the depositions, I think like expert witnesses, the cost of her, you know, talking to regular witnesses. You think she's an attorney for appeals? Yeah, if it goes to that. Because I actually don't, I'm not, they're separate? Okay. All right. Well, good to know. All right, y'all. Well, that's it for Sarah Boone. So, I mean, maybe I'll see you guys again this Friday. So, like I said, Sarah Boone again this Friday for her hearing. And then Karen Reed, I think that would be a really interesting one, too. So, Karen Reed case, there is an update. Apparently, there has been 4 members of the jury who actually, so we know that there were 5 people that directly, indirectly reached out to the defense team to let them know about, you know, charges 1 and 3 for Karen Reed, that they said they acquitted her of that. Now, there are 4 people of the jury that apparently reached out to Mr. Lawley to also say the same thing. So we'll see what happened on Friday's hearing to see, what's the state going to do moving forward? Are they going to dismiss 1 and 3 and then just go after Karen Reed for manslaughter? Who knows? Also, I think I'm going to be streaming again tomorrow. Tomorrow, I do want to cover a little bit of Alexi Treviso again. Just with some little minor stuff. And yeah, I don't know. I think it'll be sort of a busy week this week. But that's all I got for Sarah Boone today. I appreciate y'all popping in and being here. I was waiting for the video to be ready so we can watch the hearing today. Because I saw that there was already notes about today's hearing. And I didn't want to just cover the notes. I was like, I feel like that wasn't enough. I wanted to actually wait for the actual hearing. So I will see you guys tomorrow. Tomorrow we're going to be covering Alexi Treviso. And then Friday, again, Sarah Boone, Karen Reed. And guys, I will look over the audio stuff to see what you guys are talking about. Because some of you guys are saying that you guys were having audio issues, but it was fixed after you refreshed it. So hopefully, it's just a YouTube thing. Hopefully it's not on my end. But what I usually do is I'll usually take a YouTube stream. I'll upload on my YouTube channel with the edits. Like I'll take out all the, I'll try my best to, but to take out all the, I don't think today we actually did a lot of no, I think today we kind of stayed on topic, but usually I'll edit me interacting with the chat and then kind of just focus on what I'm, talking about, the topic and stuff like that. So I will listen back to see if the audio is a little bit wonky. If it is, I'll try to fix it in post edit. So if you guys couldn't watch today's stream because the audio was fucky for you or something and it's still not working, just keep an eye out on the video. I'll try to have that ready. But yeah, it was nice having you guys here. I'll see you guys a different day. I think, oh God, it's already 5 o'clock. I'm hungry. I'm starving. I'm going to go eat. But I appreciate you guys being here. Hope you guys have a good one. See you soon. Bye, peace. I'm so sorry I wasn't able to catch up with today's chat. There was a lot to cover. And because the live stream started so late and I'm getting hungry, I sometimes kind of just blast through it really quickly. Because I need to eat or something. Is she more likely to be successful on a PO due to pro se? What is she going to say? That she didn't... if she can somehow convince the appeals judge that maybe the trial judge made an incorrect decision to let her go pro se, maybe that's one argument. But I don't know. I feel like appeals is a tough one to win. It is a tough one. So I don't know if she would have any, good arguments for appeal. I don't know. Maybe. Oh, I appreciate it, Livy. You're a new sub. Yeah, thank you so much. If you guys are new subs or anything like that, I do appreciate it. I hope you guys have a good one. Take care, and I'll see you guys later. Bye. Oh, yeah. Hold on. I'm going to end my YouTube stream. I'm not going to end my Twitch stream yet. But for those of you guys who are on YouTube, see ya. Bye. Wait.